Hi, everyone. I'm Jordan Diamond. I have the privilege of serving as the president of the Environmental Law Institute, and I simply wanted to take a moment to welcome all of you here today to ELI's offices, and to everyone online. Thank you so much for taking the time to join us virtually. I do want to extend a special welcome and thank you to the Vanderbilt Law students who are here today. This would not happen without all of you, so a huge, huge thank you. As many of you may know, the Environmental Law and Policy Review, the annual review that we do, this has been a 17-year collaboration between Vanderbilt and ELI. Thank you for the chair, Linda. And thank you, Linda and Mike, for your leadership here. So we are really excited. This means a lot to us. We're really proud to be the host of the conversation today. And we hope that you're going to enjoy a day of creative discussion about tricky, thorny legal issues. As you may guess, we don't choose the easy, simple issues to feature in this review. So we're really glad that all of you are here today with our leading experts and commentators to really take a deep dive. And one note, we do want to make sure that at the end of the day, you remember there is a reception for all of you here in person. So please, although the conversations will officially end, we do have a reception afterwards, and we would love you to stay, get to know some of the other folks in the room today. With that, I did promise Linda that I would not take up a lot of time. We have a packed agenda, so I'll turn things over to Linda Brunet.
Great. Thank you so much, Jordan. And also, please let me know if you can't hear us. We have some amplifying mics and some not, so just raise your hand back there if you can't hear us. But again, welcome to Environmental Law Institute. Welcome to the hundreds of registrants on the webinar. We're delighted you could be here. And I just want to say special thanks to some ELI alumni who are here and some ELPAR alumni who are here. So it's wonderful to have everyone. Before we dive into the panel discussion, we want to give just a little background on the Environmental Law and Policy Annual Review, or ELPAR, as we affectionately call it. We just want to tell you what we're trying to achieve with this project and how we came to pick the few articles that you're going to hear about today after reviewing hundreds. And we're also going to hear a little bit about what was in the pool. So we're going to do that before we go to our first panel, and I'm going to hand it over to Mike Vandenberg, my co-instructor for the Environmental Law and Policy Annual Review class.
Thanks so much. My job here is just to give you a sense of what we're trying to accomplish. And one of those things is exemplified by the fact you see students sitting next to me here and in the audience. You're going to hear them throughout the day. We're trying to help give our students unique is an overused word, but this is truly a unique experience. We sift through all the environmental law articles out there, and they get a chance to discuss which ones really matter, to think about feasibility, and to make presentations and get used to the format and norms of doing that. So that's goal number one. Goal number two, Linda and I both serve in government, and as many of the people in the audience here did as well online and here in the room, we didn't use academic work as much as you might think. And that was in part because a law review article was 100 pages long and it had a lot of footnotes, and we didn't have time for that. But the second and maybe more important reason was that in academia, you're rewarded if you are trying to open a can just to hypothesize or make up a can opener. And you can do that and solve the problem. In the real world, you confront angry members of Congress, angry publics, angry states, whatever it might be. And so we were looking for ways to create more incentives in the academic community to be realistic about feasibility, to actually do that. How do we do that? Well, when I first started writing law review articles, the last third of every article was cut out by my colleagues so I could get tenure. And what was that last third? It was the policy recommendations where I actually grounded what I was doing. And so what we're trying to do here is to create incentives for the kind of scholars that will hear today make presentations. Create incentives for people to actually wrestle with difficult ideas, to wrestle with feasibility, to not assume a can opener whenever you want to open a can. So ultimately, then the last goal we have is to improve the quality of the legal scholarship out there by creating incentives to make it more grounded and not just more practical and feasible, but I think the underlying theoretical and empirical work will be better if it has to engage with the world as it really is, rather than a simplified world that we could imagine. So that's our underlying set of goals here. I'll pitch it back to
it's not my turn, but I do want to say, I think you were kind when you said we don't rely on the academic literature as much as you would think. I think it's fair to say we didn't rely on it at all. And that was, what we were trying to achieve with this effort. So I'm going to hand it over to our wonderful editor-in-chief this year, Sydney Schoonover, to talk a little bit about how we pick these articles.
Sure. Thank you, Professor Bregan. My name is Sydney Schoonover, and I'm a fourth year JD PhD student in law and economics at Vanderbilt. And I'm also the editor-in-chief of ELPAR this year. And just to give an overview of what our article selection process looks like, it takes place over about 15 months, so the fall and the spring semester of our school year. We start with all of the academic literature published in the last year from about 150 law journals, which includes the top 100 general interest law journals, and then all of the special interest environmental law reviews. And our goal is to identify and then eventually republish the most impactful scholarship in a condensed form that highlights the policy proposal for the purpose of delivering scholarship to academia in a more digestible form. So on those law journals, we perform a Boolean search in Westlaw, which collects any article that uses the term environment. And that's about 1,500 articles to 2,000 articles, depending on what the pool looks like that year. This year is about 1,500. We sift through these articles and we keep only those articles that are talking about the natural environment, so as opposed to, for example, a hostile workplace environment, things like that. And that gets us to about 500 articles. And then we have students screen through these articles and they identify whether these articles are answering two threshold questions. The first is whether the article addresses an issue that is of major environmental importance to environmental quality. And then the second question is whether the article includes a law or policy relevant proposal or approach that could be influential in the short or long term. And then that brings us to about 300 articles. And then those articles are evaluated by 2 students each across our 4 dimensions, or our ELPAR criteria, which are persuasiveness, impact, creativity, and feasibility. Articles that receive high marks there from student editors across those 4 dimensions are then read in depth by 2 student editors who summarize the article. We summarize about 100 articles a year, give or take. And then as a class, we meet each week. There's about 20 students, our 2 instructors, along with Professor Cox, who's our 3rd instructor. And we discuss these articles in class and debate over them. We also get help along the way from academics and experts in the field when we run into an issue that we need some assistance with. And ultimately, through our class conversation, we arrive on ELPAR's top 20 articles, which we bring to our ELPAR advisory committee. And our advisory committee consists of experts from a range of different backgrounds, including NGOs, law firms, private corporations, many different individuals from many different types of places. And during our meeting with the advisory committee, we discuss our top 20 articles, and they help us come to which of those top 20 are most worthy of recognition. And these we feature through events such as our conference here, our conference in Nashville, which was a couple of weeks ago. We publish these articles in a condensed form in the August issue of Environmental Law Reporter, and then feature them through events such as webinars, podcasts, blog posts, so on and so forth. And so that's our process. That's how we arrived at the articles that we'll be discussing today. And before I hand it back to Professor Bregan, I'd just like to say thank you to a few people who helped make this process possible. So first, thank you to our authors for joining us throughout the day today and for producing excellent scholarship that really is our goal of ELPAR. It embodies what we're trying to do. And we're very excited to hear about and discuss those articles further today. Also, thank you to Professors Vanderbilt and Bregan and Professor Cox, who's the director of the ELU program at Vanderbilt, just for all of your insights and time, expertise, motivation. We really just could not do this without you. You're fundamental and instrumental to the process. Also to Mara Pusick, who has not only assisted me and Professor Bregan throughout the year, but has truly planned a huge part of this conference, and to Jay Austin, who's the editor-in-chief of ELPAR. And then lastly, just to the ELPAR class, the process that I described takes about 15 months. It's very energy intensive, time intensive. And so to get to do it with all of you was such a pleasure this year. So thank you.
And thank you so much. And I must say that that's the first time I think that a student editor has said something so nice.
Thank you so much.
So you just became our best editor-in-chief. This gives me a chance too, though, to say that it's a privilege for Vanderbilt to work with the Environmental Law Institute. I think in this deeply polarized, often dysfunctional world that we're in, there's no more important set of organizations, not only than universities, but the kind of organizations that ELI is, nonpartisan, trying to get to the bottom of hard issues, caring about the environment, and doing so in a way that tries to build bridges and reach a broad audience. So it's a privilege for us to be able to work with ELI on this too.
Well, thank you for that as well. So as you can tell, it's quite a thorough process, but it is very much an art and not a science, as we like to say. So I'm going to hand it over to Chloe now. She's like our Steve Kornacki of ELPAR. She's going to do the numbers for us.
So good morning. Thank you all so much for being here and for joining us online. My name is Chloe Allen. I'm a third-year law student at Vanderbilt University Law School. I'm also the development editor for ELPAR, which means I have the great pleasure of crunching the numbers. So Sydney gave a fantastic overview of the process we go through for article selection. And then I get to, at the end, go through all of our spreadsheets and figure out the trends of what's going on in environmental law scholarship for the course of the year. So I'm very, very excited to share with you the results of our data analysis for the 2023-2024 cycle. And these results will also appear in the August 2025 edition of the Environmental Law Reporter. So you can see more in depth there. Could we have the next slide, please?
And we also post these numbers on the Social Science Research Network as a part of an article that the student co-author, in case you're looking for it there.
Thank you. Could I have one slide more forward? Awesome. Thank you so much. All right. So ELPAR uses an established methodology that undergoes only minor changes from year to year. And as I've said before, Sydney already gave an incredible overview of what all goes into selecting those articles. The information can also be found on ELI's website after the conference today, if you'd like to take a closer look. So this year, from those 1,500 articles that Sydney mentioned, we analyzed 335 environmental law articles that had been published through the end of August 2023 through about the middle of August 2024. And so we drew primarily from articles that had been made available through Westlaw and the journal websites. Articles that were flagged as environmental, as Sydney mentioned, got a closer look from our members who asked two primary questions. Are environmental law and policy a substantial focus of the article in question? And are environmental topics given a serious treatment rather than just incidental treatment? Are they a fundamental issue at our discussion in the article? So next slide, please. So of the 335 environmental law articles we analyzed, 226 of them, or about 67%, came from environmental law journals. These were specialized law journals that were focusing on environmental law and natural resources. And then 109 articles, or about 33% of them came from general law reviews. So the selection pool for where we're drawing these journals that we're reviewing, the ranking, we draw from rankings compiled by the Washington and Lee University School of Law rankings. We filter only to United States-based journals, and then we look at their list of specialized environmental and land use law journals and their energy and natural resource law journals, though we do exclude those publications that are not available without a special subscription. And then for the general law review selection pool, we look at the top 100 law school journals on the US News and World Report. So next slide, please. So for the 2023 through 2024 primary topics. So our students classify all of the 335 articles that we reviewed through 10 categories that are drawn from the Environmental Law Institute's subject matter index. So these 10 categories are governance, climate change, air, water, land use, natural resources, wildlife, waste, toxic substances, and land use. I want to make sure I get all 10. So all of the articles that we review receive a primary topic, and then some that are branching over more than one topic also receive a secondary topic. Also note that governance is such a broad topic. Almost any article, when you think about it, can be categorized in governance in some way. Whenever possible, if an article has both a primary and secondary topic, governance becomes that secondary topic. So this year's articles, as you can see on our chart, we had 80 governance, 58 climate change, 49 water, 45 land use, 37 energy, 18 wildlife, 17 natural resource, 15 waste, and then 6 each for air and toxic substances. And these are just for the primary topics for each of those articles. Next slide, please. And now for those secondary topics, as you can see, this is where governance becomes most of the chart. So where appropriate, articles also receive that secondary topic drawn from ELI's subject matter interest. And of this year's articles with subtopics, there were 139 governance articles, 20 climate change, 4 water, 6 land use, 1 energy, 1 wildlife, 2 natural resources, and then 3 toxic substances. But wait, we can break that big governance category down even further. So next slide,
This is a
please.
very steep Carnegie. You need khakis.
I do. So as you can see, we have a huge variety of governance subtopics that we can categorize these articles in, ranging from insurance and infrastructure to tribes, trade, and tax. We have 37 articles that were categorized in international this year. This was our most popular governance subtopic this year. Last year's most popular subtopic was environmental justice, which remains in the top 3. We had 30 environmental justice articles published this year. And then the private governance subtopic, which was introduced 2 years ago. It has been a perennial favorite since we began tracking it, and we have 33 private governance articles published this year. And then if you want a further breakdown of all of those subtopics, that's available on the slide, and that'll also be available in that data analysis that will be published in August. So next slide, please. So here we have a QR code that will direct you to the list of the top 20 articles that our students selected for the publication cycle. Next slide, please. So here are those top 20 if you didn't have time to get that QR code. So we also analyzed the top 20 articles for topic and subtopic as well to monitor those trends. Next slide, please. We had 3 of the top 20 articles that we chose came from the specialized environmental journals that I mentioned earlier. And then 17 of our top articles were published in general law reviews this year. Next slide, please. So of those primary topics and secondary topics, we had, in many ways, it matches the overall primary topics and secondary topics from overall. Though interestingly, water was the 3rd most popular primary topic overall, but we only have 1 water article in the top 20, whereas of the 335 articles, we only had 6 air topics. We also have an air topic in the primary topic. So it's not always going to be a direct 1-to-1. Next slide, please. And then of those many governance subtopics, we actually had half of our articles that had infrastructure as a subtopic made it to our top 20 this year. You can see that those 3 are going to be represented here. And then though international was the most popular governance subtopic overall, it was not represented in our top 20 articles. And then private governance and environmental justice, which were other popular subtopics, are also well represented in our top 20. Next slide, please. So that's a high level overview of our data analysis for the semester, for the publication cycle. The full summary will appear in the Environmental Law Reporter in August of 2025, and then more information about our methodology and the list of our top 20 can be found on EL's website. So thank you all so much for tuning in to get an overview of our data analysis, and I'll pass it back over to Professor Bregan.
I do think Chloe gets the Carnegie Award. I think that's really,
And I will say there's one thing about that presentation is that really dated me because I remember when there were no QR codes, and I also remember when there were no climate change articles. Like that's how long we've been doing this. So it's really interesting, watching how this develops. So
and the other thing is that obviously what this begs on some level is, well, what are the trends over time? How do these numbers compare? And one thing I would say is that one reason we don't focus more on that is that there is so much heterogeneity, so much variability in the literature, or not even the literature, in the way that these articles get posted, And
Yeah.
those change over time.
Yeah.
It makes it very, very
Yeah.
difficult, surprisingly difficult to show what those numbers would look like over a 5 or 10 year period. But we probably will include a comparison, at least to last year, in the final written document.
Yeah, Westlaw embargoes articles, which is something I'd never heard of. So I think what will make sense, given the time, is to thank you all and ask the next panel to come up while I do a few logistics. So thank you guys, you did an awesome job. And for today. So thank you so much for joining us. And I'm going to hand it over to Trip Johnson.
Perfect. Thank you, Professor Reagan. Hello, everyone. My name is Trip Johnson. I am a third-year law student at Vanderbilt Law School, and I serve as the managing editor for ELPAR. Today's panel highlights the article titled "Utilities with a Purpose," which is written by Joel Eisen and Professor Heather Payne. Joel Eisen is a professor of law at the University of Richmond Law School. Professor Eisen's research focuses on electricity, utility regulation, and clean energy topics. Before teaching, Professor Eisen served as a counsel for the U.S. House of Representatives before working for the House of Representatives. Professor Eisen was an associate attorney at McCutcheon, Doyle, Brown, and Anderson. He received his law degree at Stanford University Law School. Professor Heather Payne is a professor of law at the Ohio State University Moritz College of Law. Professor Payne has previously served as a chemical engineer and corporate executive, which enables her to bring a deep understanding of both the technical and economic implications of policies to address new realities in a carbon and water constrained world to her teaching and academic writing. Before teaching at The Ohio State University, Professor Payne taught at Seton Hall University and served as a professor of law there. She received her law degree from the University of North Carolina School of Law. Anjali Patel is our first panelist. She currently serves as the Vice President of Clean Energy at David Gardner and Associates. In this role, she builds alliances and provides research and analysis, strategic advice and planning, and policy advocacy to accelerate clean energy solutions that support decarbonization, energy, environmental, social, and economic justice. Before working at David Gardner and Associates, Anjali served as a litigation supervisor in the DC office of the People's Counsel. She earned her law degree at the University of Michigan Law School and a Master of Science in Environmental Policy from Drexel University. Our second panelist is Megan Terrell, who is a partner at Plowshare & Carr, where she provides counsel on issues regarding environmental, natural resource, and coastal law, as well as administrative, governmental, and constitutional law. Megan's experience includes working for the Louisiana Department of Justice, where she served as lead in-house counsel for the state of Louisiana during the Deepwater Horizon disaster and subsequent litigation. She received her law degree from Louisiana State University School of Law. Our final panelist is Mike O'Boyle. Mike O'Boyle is a senior director of electricity at Energy Innovation. He directs the firm's electricity program, which focuses on designing and quantifying the impacts of policies needed to affordably and reliably decarbonize the U.S. grid. Before joining Energy Innovation, Mike served as a law clerk at Jordan, Biscoff, and Heiser. Mike graduated from the San Jose O'Connor College of Law at Arizona State University, where he focused on energy and international law. I would like to welcome our authors and panelists for our first panel today.
Thank you so much. So I think I'm gonna start us off. And I just, again, want to express my sincere thanks to ELI and to Vanderbilt, to all of the students. I actually had the distinct honor of having two in the top 20 this year. So I'm thrilled to talk about this one, which Professor Eisen and I co-authored. And I want to start by really talking a little bit about the genesis of this project. So I was reading about purpose-driven organizations and was really struck by how much all of my academic research into utilities indicated that they were not going to necessarily adopt anything from this particular movement just because of the underlying structure. And the fact that utilities, especially when we're talking about state rate regulated monopolies, they just don't have the same motivations that other corporations have. And yet we tend to not bring that out as much in the academic literature when we're thinking about corporate form. And so that was really the kind of the genesis of this project, is us starting to think about, well, if this is the way that we're thinking about corporate form, about what would make it so that we can move back into the public interest? What would utilities have to do? What would we have to do to really make that work? And along with all of that, we were having lots of conversations broadly about ESG, and we still are, right? So there was a study that came out yesterday that basically said 50% of employees think that when their employers are talking about ESG, they don't actually mean to make meaningful actions based on it. It is really just greenwashing. It is all about just putting forward words with no actions behind them. And of course, we've seen multiple conversations about that in the utility space, around carbon, around other things. And so what we wanted to do with this project is really say, how do we make this real? How do we take commitments? How do we make utilities become purpose-driven organizations? And I think that one of the things that we focused on is that this is something that we see happening at the state level rather than the federal level. And so even as we move through rather tumultuous times at the federal level, actions around what we outline in this project could still occur.
And with that,
And with that,
Quite a prompt.
I guess that was my prompt one, but.
You're on.
I'm on. Also, I want to thank Vanderbilt and ELI as well. This is my second time doing this. In 2012, I was in Nashville with an audience and with commenters for something I did on renewable energy. And I'm very glad to be back. Heather's understating with her usual understatement the genesis of this project. It was a tremendous idea to think about how the literature on purpose-driven organizations could work here in this space. And we faced two basic problems right at the outset. The first one was that unlike other organizations of
Sorry, it froze for some reason, but we're back.
So I'll just repeat what I said. We gave that a lot of thought over several months about how we were going to interlock this puzzle. Heather had done a tremendous amount of reading about purpose-driven organizations. And we wanted to bring that, as she said, we wanted to bring that to bear here. And one thing I do want to make sure that I say here is that when we're unlocking the various issues that come to bear on a public policy issue of this sort, it has been enormously beneficial to be part of a team. We have published several articles together, and I think it would have been extremely difficult. I'll just speak for myself. It would have been extremely difficult for me to think through all of the various ways that we could craft a solution to help American public utilities be more socially responsive. So in the end, what we did was we did three things. The first thing we did was we looked at utilities' ESG commitments. And we found that many utilities do in fact make ESG commitments, but that they fall far short of actually capitalizing on that idea. And we recognize that part of why that is the case is that they can obfuscate what they're doing through the process of a Public Utility Commission proceeding. And I know there are some folks in this audience who are familiar with PUC proceedings and may intervene or take part in them, but they are famously, they're famous for their lack of transparency. And so we recognize that any utility could make a commitment to be socially responsible, but then they'd had to follow through with it in this lens of the Public Utility Commission proceeding. We looked at the available mechanisms for corporations to identify themselves as socially responsible, such as public benefit corporations and B Corps. And the problem we encountered was that if you thought about a utility as an organization that can use the advantages of a Public Utility Commission proceeding to its advantage, it would be extraordinarily difficult to enforce the existing mechanisms for socially responsible corporations. So here, we decided there had to be a better way to propose a public policy solution that would make utilities more socially responsible. And what we hit upon was making changes at the state level by asking public utility commissions to demand more of their utilities than they currently do. Let me put that back to you and talk about the purpose part.
Yeah, I think that really one of the things that we determined was that the existing structures didn't really work. They didn't fit what we wanted to see happen with utilities because of the specific regulatory framework that monopoly utilities exist in. And so what we did is we said, okay, so if we're looking at having this as really a purpose-driven organization, what do we need? And we needed things like additional public participation. We needed additional transparency. We needed a new corporate form that would make it so that we could start seeing actions taken in the public interest that could be verified the way that you can't currently through the system of utility regulation as it exists. And I will note that as you see us bouncing back and forth, this is basically how we write. So I have to say that I 100% echo what Professor Eisen said on the fact that this is not something that either of us could have done individually, because this is basically what happens as we're writing constantly. We're throwing ideas back and forth and really building on what the other one has said. So if you start thinking that this is a shtick, it's not. This is just this is literally just how we work. And so once we figured out that the current forms that were being thought of around socially beneficial corporate action wouldn't work, that was when we started really focusing on something completely new. And we recognize that within what we develop, there are going to be some challenges, right? Do we think that state legislatures will need to take action to make this happen? No, actually, we don't. We think that inherent within the authority that exists at the PUC level, most states, most PUCs could actually go ahead and require their utilities to do this. We're also realists, and we recognize that in a lot of cases, PUCs are probably not going to be fundamentally willing to do that? Do we think some might? It's entirely possible. Do we think that that could actually pave the way for others moving forward? Absolutely. Is this something that is going to be immediately beneficial to utility ratepayers when it happens? Yes, right. The additional focus on a broader set of stakeholders with more transparency and more accountability, we feel could only be beneficial for ratepayers as a whole.
I'll say one other thing. We were conscious when we developed this idea of public utility commissions acting to require their utilities to be more socially responsible. We operate within the constraints of a law review article, so that there are many different challenges in terms of defining and implementing what we have in mind that we simply had to put off to what might eventually be part two of this project. I think if we had tried to tackle, we agreed right from the outset that if we had tried to tackle all of the issues of getting to this point where we made this proposal, and then also defining it in such a way that it could be taken off the shelf today and then implemented nuts and bolts, chapter and verse by a public utility commission, I think that would have been extraordinarily difficult to do within the confines of any one article. So I'm very much looking forward to what the commenters might have to say about how we could refine the idea further for it to be actually picked up and used by any given commission. I'll say something else about this. Professor Payne and I strongly believe that commissions do have the authority to do this right now, and they could pick up this idea and run with it. But I'm a realist about something else. Time and space often require us as academics to put something out there as a germ of an idea that can be done in the real world. And I'm very conscious of Professor Vanderbilt's call that we should always be proposing something that can be done in the real world, but that I'm also realistic in knowing that it might not happen today. It might be 5 years from now. But when it does, we'll be ready when the phone rings. We'll be ready when the phone rings to talk about what we meant and what we had in mind and how it could be refined further for commissions to go ahead and use it. And with that, I'll just say thanks to all of you.
And I'm so glad that you raised that, because that is one of the big things that we discuss in class, right? Short-term feasibility versus long-term feasibility. And if there is a sort of a paradigm shifting piece that, you know, we want to get the idea out there. We all talked about this. We all knew it wasn't happening tomorrow, but we're glad to know you're on standby. And do you want to say something?
And the other thing, we're about to go into, I think, some really thoughtful comments here. But the other piece would be, even if PUCs can't do it, does some of the pressure that we see from the private sector to decarbonize, might it induce companies to do it even without formal governmental? Might we have some private governance at work?
And we were certainly aware, I mean, obviously, we were aware, and I'll just commend Mike for being a titan in the area of the literature on private environmental governance. I will say we're very much aware that pressure from the private sector could help achieve some of the results that we seek to accomplish here. But we're also aware, at least today, in a way that we may not have been 6 months ago, that this might be one of the most promising avenues to move forward in this current climate where ESG itself is
right.
And just from the news this morning, suffering rollbacks at the federal level. This might be something that we could look to as a place to put pressure on the utilities to do better.
Well, again, thank you for validating our process, because even though these articles were all written before the election,
Right.
our final selections were post-election. So that was sort of our analysis as well. Mike O'Boyle, we're going to turn to you. Your face is very large in our room, and we're looking forward to hearing from you.
But
I just-
not excessively so.
Not very. And you look fabulous.
Well, thank you very much, and
Before-
I'm sorry I'm not able to join you all. Can you hear me okay?
You can.
Yep.
I wanna-
Okay,
Joel
wonderful.
has a point he wants to make before you get started.
I just wanted to
Okay, go
say,
ahead.
Mike, I want to thank you for your organization's work in trying to defend and reconceptualize the Inflation Reduction Act. And I'm very, very grateful to you for that.
Wow. Thank you. Well, I can't take too much credit for that. I work with some incredible colleagues who deserve most of that credit. And yeah, we're all in this fight together, including, in the academic space, coming up with really great new ideas about how to regulate utilities and align their incentives with climate action, social justice, and many of the other things you discussed in this article. So good morning, everyone. I'm sorry I was not able to be in Washington, D.C. I'm based in San Francisco here, and just was not able to make it, but look forward to joining an ELPAR event in the future. So as was said, I'm Mike O'Boyle. I'm the Senior Director for Electricity at Energy Innovation, which is a climate and clean energy policy research organization. I'm also a Vanderbilt University undergrad alum. So Vanderbilt is near and dear to my heart. Hi to all of my fellow Commodores, and sorry about that early exit in the tournament for anyone who was paying attention to that. Kind of a bracket buster for me. Anyway.
Well, it was a total bracket buster.
Yeah, well, sometimes your heart is picking the teams over your head, and that was definitely the case for me.
Oh, yeah.
So I want to start the article, and I am reading a bit of a comment. This is against my own best practices, but there was a prompt to write a comment, and I kind of wanted to just share that for folks. So apologies for reading a bit of a script here, but I first want to commend the authors. You're exploring really much needed reforms to gas and electric utility incentives to align them with with the public interest, particularly environmental, climate, and social justice outcomes. And I agree that utilities have fallen short here. And one of the core issues is aligning utility incentives. It's pretty self-evident, right, that there's misalignment, even though wind and solar and batteries are the cheapest sort of forms of energy today. The U.S. remains well off track of international requirements to keep global temperature increases below 1.5 degrees C, with a high likelihood will also blow past 2 degrees Celsius. And this includes the electricity sector, which is a relative bright spot for U.S. global emissions. So despite recent decreases in emissions, we're not going fast enough. And the grid has to be clean before other sectors so that electrifying those sectors reduces emissions at speed and scale. So that is the task before us. And I think that's the context in which this article was written. I think the purpose-driven utility is a novel and promising concept, and underpinning it is the observation that utilities' profit-seeking motives are not aligned with the public interest, in particular environmental concerns. As someone who likely shares many of the values of the authors, I agree, but I want to call attention to a key implicit assumption here, that there is an objective public interest here that can be identified and sort of statically optimized for. And it's really recent political events that have undermined my sense that Americans share the same environmental and social equity goals that are at the heart of the author's argument about the purpose of a purpose-driven utility. In some forums, we're seeing this notion of public interest being turned on its head against climate-aligned and equity-centered efforts. And so by empowering utilities as purpose-driven entities, we should be cautious as to how that can proliferate into moral policing in a way that perhaps goes against climate or equity concerns. There is a certain safety from moralizing by narrowing the public interest towards affordable, reliable, safe service. And states can address environmental and climate risk through other policies, like clean energy standards that bind utilities with interim targets and financial penalties. We seek internal motivation from utilities because policymakers, who are heavily lobbied by corporate interests, cannot agree on the public interest enough to successfully place guardrails on regulated utilities to achieve public goals. So just throwing that out there that this can cut both ways. But with that in mind, the paper and the authors, you accurately describe and diagnose some of the root causes of misalignment between environmental and social outcomes and utility actions. Even though utilities publicly state they are already purpose-driven utilities, their duties to shareholders are evident. It's self-evident that that's a primary duty. And they increase shareholder value by investing and preserving in their capital to maintain and grow their rate base. Distributed energy resources and efficiency run counter to this goal, all other things being equal, and there are major disincentives to innovate. Utility culture is conservative, in part due to their nature as heavily regulated monopolies, where risk-taking is discouraged, and also they lack motivation through competition. I think this is the product of their existing regulatory model. There's a truism in our field that all regulation is incentive regulation. Utilities will maximize their profit given the constraints on this that the regulatory model provides. And like I said, this creates an explicit incentive to invest in capital, which maximizes returns. There are other profit motives like regulatory lag at play here. There are some innovative mechanisms that address some of these issues. Those are covered pretty fairly, I think, in the paper. But ultimately, I agree with the authors, none has been adequate to remedy the gaps between utility decision-making and the public interest that they highlight. I also agree that there's a fundamental incentive to capture regulators. And capture doesn't mean like putting them in a cage, right? It represents a sort of necessary regulatory deference to utilities based on information asymmetry, but that's the sort of least cynical form. I think you all also highlight in its worst form, it takes a much darker turn through campaign contributions at the legislature, or even PUCs who are directly elected, and a manipulation of the regulatory process to achieve their own ends and insulate themselves from competition, or even outright criminal activity, as in the case of Ohio. So I also think, so lots of agreement on the diagnosis of the problem. And I think I really commend you for sticking your neck or yourself out there and coming up with an actual affirmative proposal here when everyone else's, I think, or the common mode of action is to criticize the PUC and the regulatory model and sort of throw our hands up and say, like, everything is broken. We are really in need of innovative solutions. So I was really excited to read this paper. So let me just offer a few critiques in the spirit of improvement. And I also, Joel, when you said it would have taken many more tomes of reams of paper to describe in detail what this proposal looks like, I sympathize with that. I think you may even anticipate a lot of these critiques. So again, in the spirit of building something that can work in the real world. The first piece I want to hone in on is sort of one of the fundamental incentives that I worry even this proposal won't address. So that is, I don't think it's likely to eliminate a fundamental problem with utilities' behavior and incentives, which is preservation of their own monopoly. So one of the key incentives that exists is like, if you want to, it's one thing to align their investments or behavior with the public interest. It's another thing to ask them to step back when someone else, some competitive entity would invest in place of them. And utilities and their shareholders benefit from the balkanized structure of utility regulation in the grid. They exercise monopoly power at the expense of competitors, which drives up rates by restricting market access for cheaper power sources. increasing the need for redundant generation, it stifles innovation, and it undermines efficiency and self-generation. Would a purpose-driven utility undermine the extent of its own monopoly franchise if its growth prospects were significantly harmed by, say, refusing to build and own its own generation and opening itself up entirely to competitive bidding? Or would it support a proposal to allow competition into transmission ownership or to join a competitive market? Would it be supportive of, say, FERC Order 2023 regional planning efforts? Oh, sorry, 1920 regional planning efforts that led to greater competition against its own generation and transmission assets. So when considering the application of the purpose-driven utility concept, the architects of this charter that you propose should consider whether to state explicitly that the preservation of the monopoly should not be pursued unless it serves the other public purposes. The second one is this notion that the utility, purpose-driven utility could sort of come out of PUC regulation on its own. I think you're correct. The PUC has some latitude to pursue the public interest in this way. But I think changes to the PUC's own definition of the public interest through statute and enabling legislation would be immensely helpful here and perhaps even necessary for it to be successful. In particular, let's see, are the additional interests defined in the utilities new charter aligned with the Commission's statutory duties to the public interest? If, for example, a PUC were to encourage and approve a utility charter that centers climate change, could outsiders challenge this measure if the state did not have a climate policy or any mandate to reduce emissions? Or would the PUC even have the political capital to do so? I think the legislature can help here, expanding the PUC's working definition of the public interest and by extension, its duty to enforce it in rate making. And this is especially true if PUCs are asked to go first in creating a new kind of corporate entity whose definitions of the public interest could even be challenged as misaligned with the statutory duties of the PUC. And like no regulator or utility wants to go first. We see this, so legislation could really help. And then finally, the citizen suit provision that you described, it wasn't described in the comments initially, but there's a in the article you spell out that there's a sort of right for stakeholders to potentially sue the utility when it acts against its own charter. I worry just about unintended consequences that might actually undermine climate action here. Because to meet our climate goals, we need to build 100 to 120 gigawatts of clean energy annually for the next decade plus. That's a doubling of the pace we hit in 2024. And the grid is already straining under the weight of interconnection studies and infrastructure build out. What uncertainty do we introduce into future infrastructure plans if we allow stakeholders to sue the utilities? How about profitability or capital risk if every investment decision is tied up in litigation? At one point in the paper, stakeholders are viewed as broadly as all inhabitants of the planet. So while I share the author's goals of holding utilities accountable to their internal sustainability and justice goals, we should think carefully about opening up lawsuits to such a broad group of stakeholders and lowering the barrier of proof as well. So this is a really promising proposal. And I think it should be explored at the state level with a progressive commission and a willing utility. Aligning the internal utility management with a broader set of public service is really essential to meeting our climate goals and creating a more just world. So I commend the authors for your work in envisioning that and trying to bring it into real life. So thank you for the opportunity to comment. I look forward to the discussion.
Mike, thanks so much. And before we go to Anjali, I just want to remind the webinar participants to put your questions in the Q&A box, and over to you.
Great. Well, thank you. Thank you to Vanderbilt and to Eli for the invitation to speak, and to Professor Payne and Eisen for your scholarship and inviting commentary on your scholarship. Just as you go back and forth on your ideas, I think it's also helpful in advancing scholarship to have these discussions to really vet ideas and think about what can we do next. So before jumping into my comments, I just wanted to give a little background because I'm not sure our firm's pretty small, so many of you may not be familiar with it. David Gardner and Associates started about 24 years ago when my boss came out of the Clinton administration. The Bush administration was taking over, and he wanted to figure out how do we address these issues when potentially we have a administration that is not as climate environmentally friendly. Looking back, that may have been an actually very friendly administration, but it's all history changes things. So the purpose of our firm, we're a strategic advisory firm. We're trying to advance policies that decarbonize the highest emitting sectors. We have a group that helps co-manage the Renewable Thermal Collaborative, which is looking at mainly industrial carbonization, thermal decarbonization, which is the hardest area to decarbonize. My team looks at multiple sectors, including energy, commercial buildings, transportation, alternative fuels such as hydrogen. So we have a pretty broad spectrum of work. And then prior to joining DGA, I practiced energy law at the Office of the People's Counsel and a boutique energy law firm. Office of the People's Counsel is the consumer advocate for DC. So if you live in DC, they're your attorney when it comes to utility matters. In both these positions, I was litigating on behalf of the public interest. So really looking out for what helps consumers. My comments are going to be similar to Mike's in some ways. I commend the authors for identifying significant hurdles and that are impeding progress to decarbonizing the sector. I think you make many salient points about structural considerations and regulatory capture and acquiescence that have allowed parties to evade and in many cases hinder / undermine sectoral carbon reductions. And I really appreciate that you were trying to develop opportunities to make this real. I like the way that you phrase that, because it's important that we not just complain, that we actually figure out some solutions to moving forward. So the goals are commendable. That said, I have some concerns with the proposed fix and the workability of the proposed fix, and as well as whether, but in the spirit of we want to move this forward, I will concentrate on 3 issues. There's a lot of issues you raise in there, which I love. I'm old school, so I have a paper copy that has a lot of underlining in it. I think you hit a lot of really important issues, but I'm going to concentrate my comments on 3 things and then offer a few thoughts on each one and maybe ways to refine or adjust the approach. So my first comment is the hardest, in that I challenge your fundamental premise that commissioners have the authority to make these changes. So as Mike said, they may not be willing to make the changes, but I think in some cases they just don't have the legal authority. They're creatures, most commissions, almost all the commissions were created by statute by Congress. I believe there's at least one constitutional creation, but I couldn't remember which one it was. So don't quote me on that. But they are all of their authority stems from their statutes. And generally those statutes say they have jurisdiction over the rates, terms, and conditions of service. So it's not jurisdiction over the utility itself, it's the service, provision of service, utility service to customers. And additionally, most utilities are incorporated in Delaware, so they're not incorporated within the state that they are operating in. Things, Berkshire Hathaway, which owns multiple utilities out in the West, Southern Company, which has Alabama Power, Georgia Power, Mississippi Power, they're all incorporated in Delaware. Generally, most utilities incorporate Delaware because corporate laws are a little bit laxer there. So it's a little harder to wade into the corporate structure when the state doesn't have authority over that structure. Additionally, commissions are very reluctant to wade outside their statute because there's the concern that any decision that it comes outside their jurisdiction will be overturned by a court. So I've been in many a case where we try to ask the commission to push their authority forward and they will flat out say, no, this is not within our jurisdiction. We cannot do that. So it's very hard to get them to move forward unless there is a legislative direction. The authors bring up the Public Utility Holding Company Act, which again was
as you acknowledge, a very major change in how utilities operate. Has unfortunately since been overturned, but that was an act of Congress and it almost broke the government when they passed it. There's some really fascinating stories on the history of it. Even New York Rev, yeah, it's kind of an interesting foray into utility history, but even New York Rev, where the regulators advance, it's arguably one of the most comprehensive proactive actions by a utility commission that was done under the auspices of Governor Cuomo's energy plan. So they had some cover to say, we can act in this way because our direction is coming from above. So that said, I think there are some ways that utility commissions can act in this manner. One is that when there's a merger or acquisition, they have a little bit more control over what the corporate structure is. In DC, for example, there is one gas utility, one electric utility. Both went through major mergers and acquisitions in the 2010s. Exelon acquired Pepco and BGE. AltaGas, which is a Canadian company, acquired Washington Gas. As part of those mergers, the companies made commitments that they would abide by in order to complete the transaction. And those commitments included climate commitments. They included commitments about unregulated arms of their company. They included commitments about divestiture of generation resources. So that's one area where utility commissions do have a little bit of a broader hand in regulating what the corporate structure looks like. The other way, which Mike already mentioned, was state statutes, which expand the scope of authority of commissions. Both Maryland and DC, and I believe a couple of states out west, have incorporated into their statutory authority beyond reliable, safe service and just and reasonable rates. They've put in considerations of climate and environment, and that has made it easier for commissions to wade into the decision-making to see whether it comports with climate considerations. So that's the first issue. The second issue that it was a little concerning is the article does discuss a lot of the diversity within the energy environment, but it also sort of assumes there's a level of homogeneity among utilities. And at one point, there was a line that says they have one purpose: to serve electricity, to deliver electricity. And I think that part is a little harder in today's world, where we have a mix of utilities that are, some are still vertically integrated with generation, distribution, transmission arms. Some only have distribution, some only have transmission, some only have generation. State commissions only have authority where they're split up, only have authority over the distribution end. Transmission's regulated by FERC. Generation is unregulated unless it's part of a vertically integrated utility. So there's a lot of complications in structures, and that even if we change the corporate structure, we may not be able to put our hand into decision making from these other components. Also, many of these utilities serve gas, so it's not electric only. There's a mix. One of the two issues that we may want to look at in this regard, and Professor Payne, you brought these up. One is transparency, because there is, and Professor Eisen, you mentioned, there is an extreme lack of transparency when it comes to regulatory proceedings. And so if we can increase transparency and meaningful engagement. So a lot of utilities you talk to will say, we give you all the data. I don't know why you're complaining. Like, anytime anybody asks for something, we'll give it to you, which is not true, but also is not exactly helpful, because most of the public we're not experts in this area. Even those of us who are in this field, you know, one little portion of it. It's a highly technical, complex sector, and things like plugging in a distributed generator, adding solar generation, retiring a coal plant. These all have impacts on the system that need to be managed so we can make sure the lights stay on. And so we do need the utilities to participate in the decision making, but we need to have transparency so we can understand and trust and verify that their decision making is appropriate. And just to add on to the citizen suit provision, courts are not expert agencies. They do not have
they do make decisions about energy cases, but a lot of times they go against what the public wants because it is such a complicated field that they end up having unintended consequences. So I'd be a little wary of the citizens provision too. And then the last thing, and especially because I'm running low on time, that I'd argue that utilities do have a purpose. Their purpose right now just maybe not defined the way we want. Reliable, affordable service is extremely important. That's the whole reason they exist, is to provide electricity, energy, gas, heat to customers. Well, not gas necessarily, but heat to customers at affordable rates. And we want to make sure that we don't throw that out while incorporating climate considerations. Right now, we're in an unprecedented time with aging infrastructure, extreme load growth in some areas, extreme weather. These are all things that are really changing the system. So we need to think comprehensively and holistically and in new terms about how are we going to address and balance these issues. So I really appreciate that you brought out a new idea and how to think about this and how we can approach these issues. We just need to we need to think about how we can incorporate climate considerations into the processes we have already. So into economic and reliability analyses, into our rate cases, into making more comprehensive dockets. So you're not looking at one aspect. You don't have 20 dockets running in one commission about all the different aspects of it, especially when you have broken up industries. That allows the utilities to evade decision-making. We've heard, I do a lot of transmission work on the transmission side. The companies will say, oh, you don't have to worry about the generation. We just need to make sure that the transmission system is reliable. Well, what you're putting on the system is just as important as what you're building and why you want to build it and where you want to build it. So we need more comprehensive dockets. So thank you again. I appreciate the opportunity to comment, and I look forward to the conversation and seeing where this idea goes. Thank you.
Before we go on, I just wanted to mention, we're actually addressing the data issues you brought up this summer. That's our summer project. So we'll be back here next year for that.
Let me make a note of that.
Wonderful. Thank you for those thoughtful comments. Megan?
Yeah, it's an honor to be here today, and thanks for inviting me. The regulation of utilities, and I'll say on the top end, like Mike, I really hate reading when I'm up to talk, but this is a complicated area. Lots of issues were covered in the paper, so I do have some prepared remarks. So the regulation of utilities was not really a part of my practice until about 5 or 6 years ago. My background is environmental and natural resources more generally. But as more and more people start thinking about the impacts of climate change, utilities have become a major focus for states through legislation, climate action plans, other policy reforms at public utility commissions. So I started to learn more about public utility commissions, the ways in which they regulate utilities and rate cases. I've worked, I mentioned environmental and natural resources for more than 20 years. I find that to be a pretty complicated field just because it is very technical. I wish I had gotten a science degree when I was in college. I didn't. I got a business degree. It's not that helpful in my field of law. But I was fascinated to find out that the regulation of utilities is far more complicated than anything I've ever worked on before. And I think that's really a disservice to the consumers that require the product that the utilities are providing. And so I think there's been a push over the last decade or more to reform the way that utilities are regulated, better align traditional cost price regulation with the needs of utility customers, and more of a focus on environmental concerns. So this paper does a really great job of distilling all of these ideas that have been discussed recently, and then outlining the reason why reform is so necessary and all of the obstacles to achieving meaningful reform. So utilities have been regulated really by the same set of principles for almost a century. And we see that in environmental law as well, right? We're applying environmental acts, particularly on the federal side, that are now almost 50 years old, to the same types of industry, but also new, right? So a restoration project, for example, is going to undergo the same environmental compliance, NEPA compliance that exists for industrial development and other, development where you're filling and putting a shopping mall, for example. And restoration projects are intended to have beneficial environmental impacts, whereas the latter really have adverse environmental impacts, but we're looking at them the same way, we're permitting them exactly the same way. So utility regulation similarly is governed by a set of arcane laws that have failed to keep up with modern technological advances in energy generation and the transmission sector. So the concept behind purpose-driven utilities is noteworthy, and it really captures the objectives that should form the basis for reforming utility regulation. Ultimately, though, and I think this is a theme that we're sort of hearing with the panel, I think implementation is going to be difficult, right? Requiring utilities to create new charters and to reincorporate takes time, it takes resources, and PUCs may have the legislative or constitutional authority to do that now. I think we're still going to see pretty significant pushback from the utilities. And we see that in the just and reasonable standing that they apply now and in which they consider their rate cases. We know that public utility commissions have the general authority to consider environmental impacts of the utility practices, but for the most part, they don't. Right, so revamping PUC regulatory proceedings or requiring new types of proceedings that are mentioned in the paper, requiring that they occur on an annual basis or more frequently, I think also requires additional time and resources. Time and resources that may be better spent implementing practices that benefit the consumer and ultimately lower costs. So there's also a big focus on utilities not meeting ESG goals and sort of thinking about utility reform through the lens of ESG. Or even not setting ESG goals in the first place. And personally, I share the author's view that ESG goals should be considerations that are built into all corporate decision-making. But for all of the reasons pointed out in the paper as to why ESG can be controversial, at least when it's focused on, right, the E and the S and the G and not about risk assessment, right? I think a better approach is to focus on that risk. Investment decisions should be based on risk management. And if we see in the current political environment, it's really easy for folks to get swept up on terminology that's new or too woke for other people to consider. So really, let's focus on the risk assessment because risk assessment is built into almost everything that we do. For utilities, risk assessment should mean creating a reliable product that is consistently available at an affordable price, providing good customer service, with the flexibility to adapt and innovate to meet growing technological advancements, reducing costs, and of course, maximizing the allowed profit. Traditional cost of service regulation fails the consumers because profits are tied directly to capital investment, which disincentivizes operational efficiencies like increasing resiliency and energy efficiency and thinking about other environmental considerations. Unfortunately, with a body of regulation that's nearly a century old with the case law that goes along with it, I do worry that this new concept of a purpose-driven utility will be really difficult to implement. Sometimes the regulated community responds better through change, through transition and incentive-based programs. And while I recognize there's a really good argument that we don't have time for a long transition, sometimes you have to focus on things that are practical in order to really make change. And so I think I'm going to incorporate it into the purpose-driven utility, and you guys talk about this in the paper, is our concepts that could also be achieved potentially through performance-based regulation. So I'm going to focus a little bit on an alternative method to achieve some of the same goals through performance-based regulation of utilities. And I also agree that some of the issues you point out with performance-based regulations are true. They haven't been entirely successful, but they're still sort of in their infancy, working their way through various different states. And how you set the metrics for those performances, I think, are really important. And so, for example, customer service is one that you guys pointed out. I don't think that should be a metric at all, right? That's asking folks to provide good customer service is not something that you should be rewarded for. It should just be the baseline that you're trying to achieve. So what is performance-based regulation? It seeks to align utility incentives with the interest of consumers by compensating utilities based on their performance rather than cost alone. So the idea is that the regulatory decision makers focus on performance by setting desired results and outcomes, and then you allow the regulated utilities to create innovative strategies to achieve those outcomes. right? You're not telling them in order to get to Y, you have to implement X. You're just telling them what Y should be and then giving them the space to innovate and be creative about how they reach that ultimate outcome that you said. So right now, we know that utilities are trying to figure out how to incorporate emerging technologies like renewable energy, distributed energy resources, demand side management, electric vehicles, smart grid technologies, and energy efficiency into their practices. But again, traditional cost-based regulation disincentivizes the modernization of utilities because of the tie between CapEx and profits. Effective performance-based regulation should incentivize cost efficiency, remove the throughput incentive, equalize CapEx and OpEx incentives, and incentivize targeted outcomes. But to work, we first really need to understand the business as usual outcomes and set incentive levels to avoid incentivizing the status quo. Voluntary carbon markets offer a strange but an interesting parallel, right? There's a concept in voluntary carbon markets known as additionality. And additionality means that the project activity must exceed what would normally have occurred. And if project activities are not considered additional, you can't generate carbon offsets. So similarly, utility practices that do not exceed traditional outcomes that would have ordinarily occurred should not generate incentive payments to the utilities. Traditional utility outputs include objectives like safety and reliability and affordability, but more modern objectives might be outcomes like grid resiliency, energy efficiency, reduce energy burden, carbon emission reductions, system flexibility, and energy diversity, distributed generation, and improved human health. And so what are some of the key strategies to achieving successful performance-based regulation? Really clear goal setting, right? Identifying clear and precise and measurable metrics that are standardized, specific, quantifiable, and based on reliable data, aligning the benefits and the rewards, evaluation and third-party verification. Transparency is a theme that we've heard throughout this panel, public databases, metrics, scorecards that the public can review and see how their utilities are performing. And one option for incentive payments under performance-based regulation might be a base return on equity, similar to what exists now in rate cases, plus performance incentive payments with a maximum ROE cap. And so the ROE may go down if the utility does not meet the outcomes that are set, but you might have that they may not go down below a base return on equity, or return on equity can go up if the utility successfully achieves certain metrics, but then capping the maximum rate of what the ROE might look like. So just to sort of wrap up a little bit, this was a fascinating experience, sort of dive into all of these issues. I think the goals that we're all trying to achieve are laudable goals that we need to get to. There's probably just a debate about what's the best way to get there, right? But we know that it's beyond time for utility reform. We need to incentivize the utilities to incorporate modern technology and energy options into their practices to keep up with the growing demand while keeping power affordable for the average consumer. That's going to require innovation, stakeholder input, and consumer pressure to counter the political capital utilities spend on maintaining the status quo. The growing demand for energy keeps the economic markets bullish, though, on investment in utilities. So let's refocus the discussion around managing risk and investing and provide space for that market innovation.
Thank you. All right, we're going to the authors first to respond, and wow, your commenters really did their job. Very impressive.
That's why we do this.
Yeah, we'll be glad to answer all of those. Every single one.
Maybe 8.
Heather's been taking copious notes here, so I want to say something before she responds. We have thought about every single one of these questions at some point during this project. And some of the, could we do this? Should we do this? Should we do PBR instead? Should we rely upon other means of holding utilities' feet to the fire? Of course, but again, within the limitations of a law review article, there's only so much we can do to address every single issue. But I want you all to know we have thought about virtually everything here in some way, shape, or form. Go ahead.
Yeah, so just to follow up on that, for those of you not used to submitting law review articles, right? The sweet spot is usually somewhere between like 18,000 and 22,000 words. And if you get over 25, your chances of getting picked up by a really good law journal end up going down, okay? We were at over 30,000 words when we submitted this article for publication. And the final version is really actually, it didn't get cut much at all through the process, which meant that the authors or the editors, as they went through it, really saw that there wasn't something that we could cut out. And so when Professor Eisen notes that we thought about many of these things, we really did. The problem is that we were already way over what most law review articles would want us to submit as a potential length for publication. I do think that the transparency piece has come up, and it's something that we do feel very passionately about. And that actually is literally our summer project. We've already started outlining it and mapping it, because we recognize that so much of what we talk about and so much of what we want to do can't work without that fundamental layer of transparency. Not all of us can be in every single detail, but we shouldn't have to be in order to make it so that utilities are held accountable in a way that makes it so that they are working for all of us. And I think it is really, and thank you so much to all of our commenters. You are amazing and gave us plenty to think about as we do think about potentially putting together the second part of this at some point when we see that implementation might be on the horizon somewhere. I think that safe, affordable, reliable is something that is a mantra within the industry. And I think that one of the things that we tried to do with this piece that obviously I think needs to happen even more in the future is so often that is used as a shield toward change, right? That's what a utility will put up to say, we don't need to do anything else. And so I really appreciate the conversation around how do we actually not stop talking about safe, affordable, reliable, but how do we actually wrap other things into that make it so that we're not losing safe, affordable, reliable, but we aren't stopping there either. And we're not allowing utilities to use it as the stopping place, because that's what they're doing right now. So any other thoughts?
A couple of things I want to answer. First of all, thanks to the commenters. You are significantly stronger and well prepared than most academic commenters on this particular project, and we really appreciate it. I've noticed that the questions fall into three basic buckets. Could we do it? Should we do it? What would it take to do it? The what would it take to do it? I'll just say we understand that it might well take positive legislation in a state to do it, but that shouldn't deter the progressive state and the progressive utility from doing it. It just might be a different avenue of developing and fleshing out the concept to give authority to the PUC. So I appreciate the fact that there might be limitations on a commission right now to do this. Second, using other programs, PBR, all the energy efficiency and other programs, Mike, that you mentioned, to put pressure on utilities to do better. Well, yes, of course, they should, but it seemed to us that a more wholesale change was necessary to the fundamental form of the utility and what it does to bring this about. I was sitting through a presentation yesterday about community solar in my home state of Virginia, and you can see that the utilities incentives in very fundamental and I will agree, very technical ways were oriented toward making sure this program never succeeded. And we can continue to develop these wonderful, innovative programs, and for students in the room, you'll be counseled to or working with folks who are trying to make these programs happen. But it seemed to us as we were going through this that a much more fundamental change was required. And I think the level of engagement you see here with this work shows you something. You know that when there are lots of questions and lots of issues and some pushback at the idea, that it's an idea worth developing. And we are very much heartened by that. And we hope the rest of you will have some thoughts as well about how to proceed further. But rest assured, I mean, we've thought about many of these issues. We just couldn't cram them into one law review article, so that there are times when what we say sounds like a bit of shorthand about what the industry and how it's characterized. And if we had spent 5,000 words to talk about all the different ways that utilities structure themselves, we would not be sitting here today, because the article would have been far too long. We appreciate that, and that's something that feels like part of a round two of this. But we look forward to hearing what you all have
To be
say.
honest, that's part of the reason why we have ELPAR. I don't know about you all, but in my view, the academic discourse has evolved in the last couple of decades into this kind of ritualized thing where you come in and you present a paper, which has already been essentially published. And then the audience pretends to ask questions, which are really statements about your paper. And then you pretend to take notes on all the questions they ask, but you don't really change your paper. And we call that a workshop, and we move on. And what we're trying to do here is have a much more, I think you got it from your commenters, a much more truly engaged process.
Which is
And then it
fabulous.
produces short versions.
I don't think they're gonna stipulate they pretend to take notes.
I'm sorry. This process, that's not.
Because
And I-
we had fabulous commenters.
I want to commend you for being an environmental lawyer first and then an energy lawyer.
That's
Right.
That's
Megan and I
hardcore.
were talking about that
That's hardcore.
that those of us who started as environmental lawyers
Yeah.
really didn't have to bother with energy law and,
Yeah.
until much more recently.
Uh-oh.
We're gonna let our wonderful Vanderbilt Law student Trip ask the first question, and then we've got some great questions on the webinar, and I'm sure in the room.
Perfect. Well, thank you, Professor Reagan. Thank you for this insightful panel. Just to kick off the question portion of this panel, how would customers and other stakeholders that be empowered through a purpose-driven model that you proposed?
I think I wanted to, in responding to that question, I also want to respond to something that Mike said. And also, we're well aware that there might be, not everybody's going to be perfect in responding to this and always do the right thing. But what we wanted to make sure happened was that a large variety of stakeholders, maybe not everybody on the planet, but certainly the customers of an individual utility within its footprint, would have the ability to help shape the contours of what the utility would look like and would be empowered that way. And Mike, I appreciate that there might be customers within Dominion or Duke Energy's footprint who might not see it the same way that you and I do, but the alternative is the lack of transparency and the abject lack of public participation that we have now. And we just did a project about using artificial intelligence to empower interveners in PUC proceedings, where we've simply found that the imbalance between the data and technical analysis that a utility can bring to the table and that which the public can bring to the table is just simply a mismatch. And so I think one way to conceptualize the answer to your question is to say we're going to put ordinary people and others in the position where they have the ability to help shape the future of what a utility does.
And that transparency, I think, keeps coming back to transparency, but that transparency really will enable so much more participation and really the ability to communicate around what the utility is doing and whether broadly the people served by the utility think that that's the right direction, right? Right now, we have the ability to obfuscate in utility proceedings to such an incredible degree. And really, the way that customers in our view can very much be helped is by participating and by making it so that there is that transparency.
Any commenters want to jump in on anything? If not, we'll go next. Okay, great. Sure. I was gonna go to a webinar person, but absolutely. But I super appreciate your raising your hand. So hold on one second. So one of the questions that a webinar, because I like to make the webinar participants feel like they belong. And Mike, I want you to jump in.
Hello, webinar participants.
So one of the questions is whether the recent issues with data center and EV future power demand they have an impact on your approach to utilities in this article, because load has really been much more steady for so many years. So does that have any influence in your thinking? And
I don't think it does. I mean, both of us have thought about increasing load and especially since we actually proposed a use for AI in our most recent article, have thought about it. And I don't think it alters this proposal at all. It doesn't matter. If anything, it might make adopting this kind of model easier when you actually have load growth occurring than when you don't.
And you have a number of different public policy decisions that have to be made about how to meet that load growth. What is the next increment of generation that's going to be built? Where is it going to come from? Is it going to be climate friendly? Is that new increment itself going to be part of a PBR regime or something like that? I don't think it changes the basic analysis, but it makes us aware that there are challenges we confront in terms of meeting that incredible demand growth over the next decade. I speak from a state where 26% of electricity right now goes to serve data centers.
what was it,
26% in Virginia.
A follow-up on that, if I may, so one question I had on that is whether your proposal might ultimately get reshaped a little bit to deal with the notion that maybe it will be more difficult to induce it to become the form of corporate organization for distribution utilities, but maybe on the generation side, if you're Amazon or Microsoft and you're essentially having to build new power plants, maybe the corporate form that you organize to build the new plant, to supply the power, would be structured around a B Corp type of form. That would be one. And the second is just, I worry, given the research by Michael Wera from Stanford from several years ago, Tyler Norris has a piece out, a working paper from Duke, all of which suggests that there is a long history of overestimation of electricity demand. There's an obvious reason for that. If you get compensated based on your capital investment, you want a reason to make a capital investment. Once you do, then you've got to keep using it. Otherwise, you're right. And you can see us getting into that habit. We have a current little project, as I mentioned before the program started, where we're trying to understand if the users of AI understood the electricity demand and carbon emissions associated with their use, would that shift their use toward lower carbon, lower electricity demand companies? Do we know? We don't. I'm just sort of wondering whether there are some ways in which your idea might actually be more promising, as you kind of signaled it might.
Sure. One way in which we might think about it is in the states that still have IRPs, we might look for increased participation by stakeholders who will try to counteract those assumptions about load growth. Might be that sort of thing.
And so, yeah, there is about half the states still have IRPs. There actually is a very real concern that a lot of the load growth that's being forecast is what's termed phantom load growth, right? So that if I am trying to build a data center, I might be approaching 5, 6, 10 different utilities to see where I'm actually going to be able to get that load first. But I'm not telling all of the other ones that I'm talking to everybody else. And so the challenge is that it's basically impossible to figure out at this point in time how much of that load growth is real. And so Central Ohio is expecting to basically have the amount of load as New York, the same load as New York City because of data center location. And the likelihood that that is going to happen, I think, is pretty small because a bunch of that load is going to end up being served in other places.
Yeah.
We are seeing specific data center developers who are looking not so much where the fiber is located, which is how we've ended up with so much focus in Northern Virginia, but where can they get renewables built quickly? Because it is easier to get a fiber line somewhere than it is to get a transmission line. And so they're actually, we are starting to see some data center developers actually do that and start planning on where can I basically build a large solar plus storage and then plan on getting the data line there as opposed to something else.
I'm mindful of time and I.
I mean, some of the demand for renewable energy is ESG in action. These are large corporations that want to reduce their climate impact at the same time that they're growing load. So,
and that's an opportunity. I was about to say the exact same thing, that the Amazon, Google, and Microsoft might be good targets for that sort of thing. Go ahead.
Did you want
Yeah, just a quick addition to that. I think the load growth issue is part of, it actually aligns with the comment that you make in your article about integrating climate as a risk. Because it's a risk to the business, it's a risk to customers. Load growth is the same thing in that we need to be looking at multiple scenarios of how to plan. It's not, there is no single solution. We don't know what the future looks like. Load demand growth was flat for 30 years in part because we had a lot of energy efficiency methods integrated. And some of the demand centers, there are energy efficiency innovations that are not taking place, like using the heat and reusing it in other industries, which both reduce demand and help offset other concerns. But this is one where we have to plan more comprehensive, back to planning more comprehensively. We need to look at multiple scenarios in the process.
I want to take one more question, then I'm hoping, because we go to break, that you all can hang out and people can come chat with you. And I have to call on Nick, who was one of the summarizers of your article and made a great case for picking it. So Nick.
Thank you, Nick.
I really loved your article. And one of the questions I think underlying the commenters' comments and that we also discussed in class that I would love you guys to elaborate on is, could you expand on the merits of empowering the PUC to implement this change through the existing regulatory system versus just looking to the state legislature to mandate the sort of behavior we'd like to see outside of the regulatory system?
So I think it was really twofold. The first is that legislatures have a huge number of things on their plate at any given time, right? Trying to get them to focus on energy issues at all can be challenging. And so we saw much more of an opportunity because we actually do think that PUCs could do this. And so given that they're already focused on these issues, they already have expertise in these areas. That was one reason why we made the proposal to say you could do this through PUCs without the legislative action.
Yeah, my home state legislature in Virginia is the General Assembly operates on a 3-month calendar. Everything is done in breakneck fashion. I mean, there is obviously lots of preparatory activity during the summer and fall beforehand, but everything happens at lightning speed. And the idea of fleshing out all of the issues that the commenters have brought to our attention and would certainly bring to the attention of legislators would be extraordinarily difficult. And so part of this is just simply a timing issue. Using an existing authority instead of trying to create one. The second problem is that many legislatures, including my own, face pressures from the utilities themselves. Dominion is a heavy campaign contributor to the Virginia General Assembly, and I personally have stood in front of committees of the Virginia General Assembly and seen good legislation die. So that part of this is trying to use an existing authority, but as all three commenters have suggested, if it eventually does take positive legislation at a state level, because a commission is recalcitrant for one reason or another, then we're certainly open to that. And we're happy to advise legislators on how to do the right thing.
Well, unfortunately, we're out of time and I want to keep us on pace. So if you all would hang out, that'd be wonderful, but maybe hang out over there so the next panel can get situated because we're going to try to stick to 10 minutes. I just thought this was an excellent, excellent discussion and please join me in thanking. Okay, we have one amplified microphone for this exact moment to get everyone quiet so we can start on our next one. And I'm going to hand it over to Jason Teets, third-year law student at Vanderbilt, to introduce our panel.
So in this panel, we will be talking about disrupting utility law for water justice by Sharmila Murthy. Professor Murthy is a professor of law and public policy at Northeastern University. Following law school, she clerked for Martha Craig Daughtry on the Sixth Circuit Court of Appeal. After that clerkship, Professor Murthy spent 3 years working for the Legal Aid Society of Middle Tennessee and the Cumberlands, and 2 years working in private practice with the law firm Lisa Braithwaite. Professor Murthy also served on the White House Council on Environmental Quality during the Biden administration. She is a graduate of Harvard Law School. We also have a number of experts in the field who will be providing comments and insight. Caroline Burt is the Legislative Director for Sustainability in the Federal Advocacy Department at the National League of Cities. She serves on the Board of Directors for PACE Nation, a national nonprofit whose mission is to promote property-assessed clean energy financing. She is also a past member of the Cary Institute Forest Pest Advisory Committee. And prior to joining the National League of Cities, she served as an Associate Director of Government and Public Affairs at the American Society for Interior Designers. She also formerly worked for Burns & Rowe, a private engineering and construction company, in their government affairs office in Washington, D.C. Caroline received her master's degree in public administration from American University in Washington, D.C., and her Bachelor of Arts in Political Science from Trinity College in Hartford, Connecticut. We also have Robert Ballinger. Mr. Ballinger is an attorney for Philadelphia's Community Legal Services, or CLS, where he serves as the supervising attorney for the Energy Union. He is the co-editor of Chapter 9, Residential Utility Service, of the Pennsylvania Consumer Law Treatise, a co-author of Pennsylvania Real Estate Tax Sales and Municipal Claims, and has presented at the Pennsylvania Legal Aid Network and the Pennsylvania Bar Institute concerning utility issues. Mr. Ballinger received his JD and Master's in Social Work from the University of Pennsylvania. We also have Stephen Wilborn. Steve Wilborn is the Judge Harry A. Spencer Professor of Law at the University of Nebraska Law School. Mr. Wilborn has been a visiting scholar at schools in Austria, Canada, and England. He serves as one of Nebraska's commissioners to the Uniform Law Commission and is president of the International Association of Labor Law Journals. He received his JD and Masters of Counseling from the University of Wisconsin. And finally, we have Tracy Meehan. Tracy Meehan is the Executive Director of Government Affairs for the American Water Works Association. He was principal with the Cadmus Group Incorporated, an environmental consulting firm, from 2004 to 2014. He has served as an assistant administrator for water at the United States Environmental Protection Agency from 2001 to 2003. He also served as the director of the Michigan Office of the Great Lakes from 1993 to 2001. And prior to that was the director of the Missouri Department of Natural Resources. Mr. Meehan received his JD from St. Louis University School of Law.
Wonderful, thank you, Professor.
Hi, good morning. Could I
Good
please have the
morning.
slides queued up? Well, while we're waiting for those to get queued up, let me just first
Sure.
say how grateful I am to be here, to have my article Disrupting Utility Law for Water Justice to be selected in ELPAR. Just big thanks to the Environmental Law Institute, to Vanderbilt University Law School, and to all the students. I was honestly blown away by your selection process and just feel so humbled. And I want to extend my special thanks to all of the panelists who took time out of their very busy schedules to read the article and be with us today. So first, big thanks. Next slide. So in what I'd like to do over the next 15 minutes is just really briefly walk you through the article. And my remarks are going to follow the 4 parts of my article loosely. First, I want to talk about why water rates are rising in the US. I then want to try to situate this discussion of water within the broader context of public utility law. And I will say one thing that I found really fascinating about the last panel was that they were just talking about safe, affordable, and reliable service. But actually, this question of affordability is actually not so common in the water sector. I then want to talk about why that is and why the key principles of water rate making are often perceived as barriers to affordable rates. And then finally, I want to identify a few case studies from across the country that I studied, including one from Philadelphia that we'll hear about, that really got me thinking that perhaps we could use the Uniform Law Commission process as a way to develop a model law to help make some of those gray areas of the law more clear so that more utilities could address the question of affordability, which would be better for low-income families, disabled families, seniors that are living on fixed incomes, while also in many cases helping the utilities' bottom line. Next slide. So I'm going to start with rising water rates. And for me, this question really came to the forefront. Next, please. Came to the question, to the forefront about a decade ago, because in Detroit, Michigan, which was in the middle of a bankruptcy proceeding, began to cut off the water to thousands of households. This raised significant public health concerns. This reached national and even international attention. And the reality is that the utility was facing rising rates, was seeking to ensure that customers would have access to this key service, and ultimately was looking to develop an affordability program. The question was, how do they fund it? Do they fund it just with charity, i.e. from the United Way, perhaps other sources of revenue, or could they actually use their own water revenues to help cross-subsidize some of the lower income families that couldn't afford it? And that was really the question that got me interested in the topic that I'm talking about today. Next slide, please. Utilities are facing tremendous pressures. Water and wastewater facilities, they also deal with stormwater. I'm going to generally just use the term water. It depends on how they're configured, depending on the state and the jurisdiction. But look, most water pipes and wastewater pipes, they're underground, right? You don't see them out of sight, out of mind. That infrastructure has been degrading. There's historically been declining federal funds until over the last handful of years between the American Rescue Plan, the Bipartisan Infrastructure Law, the Inflation Reduction Act. We did have a much needed infusion of federal funds into wastewater and water infrastructure, but it's certainly not enough. In addition, many communities face this conundrum. Do they need clean water or affordable water? Why? Because environmental compliance is actually expensive. So you have the Safe Drinking Water Act, you have the Clean Water Act. This image is of a combined sewer overflow. Basic idea being that back in the day, they thought it was a great idea to have stormwater pipes connected to your sewer pipes, which is why for those of us that live in older cities, I live in Boston, you don't swim in certain waterways after a big rain because you may actually have raw sewage going into those waterways. This is expensive to replace. In addition, there are other water resource challenges exacerbated by climate change. And then finally, a shrinking rate base. What do I mean by that? A city like Detroit was once had a very large population. And then over a number of decades, a lot of that population moved to the suburbs. So now you have a smaller population that is responsible for a huge set of pipes and infrastructure to maintain. Next slide. Because of the COVID pandemic, the salience of water for public health really became a national issue. And you had a lot of cities actually issuing moratoria on water shutoffs. In addition, Congress actually appropriated funds to create the first ever low-income water household assistance program modeled on a similar program in the energy sector. This was a much-needed infusion of funds that allowed a lot of utilities to offer affordability programs, but these funds have since dried up and the program is no longer awarding funds. Next slide, please. So then this returns me to this question of utilities that are facing rising rates that in some areas have significant parts of their population that cannot afford these rising rates. How can they fund these programs? So I turned to the legal scholarship and I realized, wow, there's actually not a lot of legal scholarship on water rate making. Lots on water from other perspectives, but not necessarily on rate making. Next slide. And so really quick overview of public utility law. What I want to describe, what scholars have sort of described as the rise, fall, and resurgence of public utility law. So this idea is that when there is a private enterprise that is affected with the public interest, this is a term that the Supreme Court coined back in the late 1800s, drawing back on a 17th century treatise. And it was in the context of grain elevators. But they basically said any kind of natural monopoly, and so gas, electricity, water, natural monopolies, you can regulate rates in the public interest. And so fast, next please. So, however, in the 1970s, we had deregulation. So the public interest model began to go a little bit out of vogue. And then we had so-called disruptive technology. I think the image here gives you the best example. The cell phones that many of us have replaced telecom, right? And so in that sense, the need for rate regulation over a natural monopoly in many ways caused a lot of people to say, well, maybe we don't need public utility law quite as much anymore. Next. And even in the electricity sector, this was a question of, well, if people are defecting from the grid, maybe we don't need rate regulation. Other scholars have argued not so fast. Electricity generation is very complicated. And even if people put up solar panels or have wind turbines, they're still going to need to be connected to the grid. Next slide. So in the article, I posit that there hasn't been any technological disruption in the water sector per se. Sure, we've had innovation in the form of desalination or wastewater reuse, or perhaps you might even say in the fact that we now sell water in bottles. But really what we have seen is social disruption, like I was talking to you about in Detroit, or like the Flint water crisis, where people were concerned about lead in their water. Next. So now I want to turn to, once again, thinking about the utilities perspective. Why is it that they can't just simply create affordability programs? Next. I want to start with the premise that for many utilities, there's actually a business case to having an affordable program. Why? Because if you don't have to, it's much easier for a utility to have a guaranteed source of revenue, even if it's a smaller amount, rather than sometimes people pay, sometimes they don't pay. There's also costs associated with disconnection and reconnection. Utilities then have bad debt on their books, and they have to explain that to bondholders. And in order to be able to actually fund infrastructure projects, they want to actually have a good bond rating. So for many utilities, being able to think about financially sustainable ways to develop affordability programs is in their interest too. And by saying that, I mean using their own water rate revenues to actually fund those programs. Next. This is a gray area of the law. In most jurisdictions, this is just not explicit at all, whether or not they're permitted or not. But because rate-making proceedings are complex, they're long, they're expensive, a lot of utilities are discouraged from wanting to take a step because they're fearful that someone may say, this is not a lawful program. And here's why. Next slide. The key principles of water rate making are that the rate should generally reflect cost of service, and they should be just, reasonable, and non-discriminatory, very similar to the discussion in the panel before. But once again, we don't see affordable in there. Next. And I want to highlight this term non-discriminatory, because usually all the households or all the residents within an area are considered to be part of the same rate class. And so if you are charging lower income people less or giving them some sort of subsidy, you could have other people say, hey, you're discriminating against me. A sort of unusual, perhaps, understanding of non-discriminatory, but that's the gray area that is causing a lot of utilities to be more reluctant to go to actually create these programs. Next. In addition, some states actually have constitutional barriers. Sometimes they're explicit, sometimes they're also in the gray area. And a good example of a gray area is a gift clause, i.e., you can't use public funds for a private purpose. That should sort of seem pretty basic, but once again, this idea of cross-subsidizing low-income people could potentially, people are concerned that could run afoul of these clauses. And then taxpayer revolt clauses, i.e., California is a great example of this, where public utilities cannot charge rates that go beyond the actual proportional cost of service to that resident. Next. So this led me to look at, well, how is it that there are, in fact, a number of places across our country that are, in fact, adopting water affordability programs, even though some of them had been in the gray area. Next. The first example was from Philadelphia, and Philadelphia really made news as being the first income-based water tariff structure in the nation. And I was so curious, how did they do this? How did they do this? And I know Robert can talk more about this, but really, I saw this and there was tremendous community advocacy around this, and so a lot of work. But when I really looked at the fine print, it seemed like what they were saying was that bills issued pursuant to the income-based water rate assistance program, they just cross-referenced a section that said, yes, these rates are just, reasonable, and non-discriminatory. In other words, the code itself was just taking what was gray and saying, no, this program is not discriminatory. This program is in fact charging just and reasonable rates. Next slide. This concerns Atlanta, which also has home rule authority. So in some states, states can delegate authority down to the municipal level. And the state constitution says municipalities, you can't actually use public funds for a private person or a private corporation. And similarly, in Atlanta, they had a significant raise in rates to deal with Clean Water Act compliance questions. And what they did is they said, we don't think this is going to violate the Atlanta Constitution. Why? Because this program that is about water conservation and helping low-income people is tied to providing good service for the entire city, and it relates to our own ability, our own costs of service. And so they are reasonable and customary costs of operating that system. Last slide. Now, I already told you that California has a unusual, maybe not unusual, but it has a state constitutional provision that prohibits public utilities from charging rates. But investor-owned utilities, private utilities, are in fact encouraged to provide customer assistance programs that makes water affordable. And I think California really highlights the complexity and the fragmentation in this area, where you have within the same state, private and public utilities actually operating under very different rules. So despite this, next slide, please. For the many, many, many jurisdictions across the US that are in the gray area, I think there's great potential to draw on the lessons from Philadelphia, to draw on the lessons from Atlanta, and to basically develop a model law through the Uniform Law Commission. And I'm so delighted that we have, honestly, I'm just so delighted with everybody on this panel that's going to bring their expertise, but also Steve Wilburn, who will be able to talk more about the Uniform Law Commission. And although there are challenges, I'm just thrilled to have this opportunity to take this kind of germ of an idea and see whether or not we can really take it from the ivory tower in an academic article out into the real world. So with that, I just want to say thank you. Next slide, just say thank you. And that's it.
Thank you again. And thank you. That was great. And Robert, you're up next. And I just want to remind the webinar participants to put their questions in the chat or the Q&A box. Thanks.
Well, thank you very much for the opportunity. I'm really pleased to be here. I don't have slides. If you want slides, I've presented about Philadelphia's water affordability program 100 times, so I'll send them to you. But I just want to talk a little bit more today and start off with sort of who am I and what do I bring to this conversation. So I'm an attorney at CLS, Community Legal Services of Philadelphia, which is a nonprofit legal aid law firm that provides direct representation to economically vulnerable Philadelphia households across a broad range of civil legal needs. My focus is the home environment, right? So I'm an environmental lawyer too. But I focus on making sure that every Philadelphia household has access to affordable and continuous heat, electricity, and of course, water and sanitation services in their home. So as a representative of those who struggle with affordability, I know those experiences very well. In addition, however, I serve as the public advocate in Philadelphia, which means that my office is the designated counterpoint to the water department whenever the water department wants to increase rates and charges. And so we have an independent rate board that makes the final decision about rates and charges. So I'm kind of coming from both of those perspectives when I approach issues having to do with water affordability. Communities around the United States are struggling with these issues, as Professor Murthy points out. Water rates are rising far faster than inflation. And, the causes are neglected and failing infrastructure, regulatory compliance, a whole host of factors that impact on the costs of delivering the service that we need. But unaffordable water bills disproportionately burden communities of color. And the consequences are shutoffs, risks of housing instability, threats to family unity, and of course, health and safety risks, right? And so my clients go through all of these things. And unfortunately, solutions for a lot of households around the country are unavailing. So we look at examples. I love that Philadelphia was spotlighted as one example. I'm not going to dwell on Philadelphia too much, except to maybe talk a little bit about sort of my mindset in approaching water affordability. But I also want to flag that just last month, DeKalb County, Georgia, passed legislation requiring income-based water rates and charges, and they specifically pointed to Philadelphia and Baltimore as examples to draw upon. So I anticipate there will be more examples in the future of municipalities, counties, municipal authorities adopting legislation and making the move toward income-based rates and charges. I'm really excited about this proposal to craft the model state law, and I want to publicly offer here today to volunteer in any way that I can to help with that effort. And I think, the substantive need to provide guidance on affordable water rate structures is really, really important. But I want to bring to the conversation a few other things that I would like for a model state law to also deal with. Some of these principles of utility law and rate making, I think, can use elaboration, perhaps modernization, and even maybe rejuvenation in some ways. I think this is an important opportunity to sort of restate and modernize the way we look at affordability of these life essential services. So I'll start with sort of my foundation in utility law, which is the common law duty to serve. A utility is vested with the obligation to provide to all of those who can take pursuant to its tariff that vital service, whatever it may be, electricity, gas, or water. But the duty to serve means more than just the connection, right? The physical connection to the utility service. It also means the ongoing provision, reasonably continuous of that actual service itself. And at common law, utilities were required to provide that service whether or not it was profitable, and even to customers who couldn't always afford to pay in full. So we seem to have lost that a little bit along the way as we've looked at cost-based rate making, this notion that utilities really are vested with that duty to serve. And I think a model statute could elaborate upon that. And from my perspective, that sort of foundation to the duty to serve is that no one should be deprived of a life essential service because they simply can't afford to pay for it. That to me weakens the duty to serve rather than fulfilling it. Income-based water rates and charges are in that sense a manner of fulfilling the duty to serve. As a corollary to the utilities duty to serve, utilities are subject to the United States constitutionally based standard of just and reasonable rates. And I know that this appears in just about every statute regarding utility law. It's in Philadelphia's Home Rule Charter and Philadelphia Code. But just and reasonable has a particular meaning when it comes to federal law, because rates that are set too low may be confiscatory. Right? So that's the sort of constitutional hook. But if they're too high, they can also impair users' access to that important property interest in continued service. So there's no rate standard that's more exacting than just and reasonable. And it requires the rate-making authority to balance competing interests, right? So the utility has an interest in sufficient revenues, but the consumers have an interest in efficient service at the least cost available to them. So when we look at these two things together, the duty to serve and the corresponding obligation to impose only those rates that are just and reasonable, we can sort of observe some touchstones for what low-income rate making should look like, right? So the goal of low-income rates should be to ensure that the utility can fulfill its duty to serve. So we need to set those rates to produce bill burdens for the low-income customers that is, as Professor Murthy points out, helps the utility with attaining a predictable stream of revenues, right, from the low-income households. So that's one objective of low-income rates. But also, when we look at establishing low-income rates, we can't do so in a vacuum. And this is where I put my public advocate hat back on and say, it's also about determining just and reasonable rates for the entire customer population and all the classifications within it. But we can't look just at the low-income portion and say, well, that's just and reasonable without considering the impacts on the utility service territory as a whole and making sure that all the competing interests are balanced when we derive just and reasonable rates. Finally, there's sort of a separate requirement that Professor Murthy completely is correct about touching upon, which is the prohibition on unreasonably discriminatory rates and charges. And again, this derives from common law. And what the requirement doesn't do is it doesn't require uniformity, right? Reasonable classifications are acceptable. We know this. We know that public policy objectives can be promoted through rates and charges, efficiency and conservation, notably, so can affordability. So to be impermissible, rates must be found to unreasonably favor some to the undue benefit of others. And advocates such as myself in the low-income space will point out that a standard bill, a uniform bill, produces a household affordability impact that is very different for the low-income customer than the high-income or even the moderate-income household. So the bill burden is what we're focused on. What's the burden of the bill on a low-income household compared to the burden on a non-low-income household? And I submit that if the bill burdens can be made equivalent, that there is no unreasonable discrimination in terms of the impact of affordable bills and affordable rates and charges. So the last thing, I don't know how I'm doing on time, but the last.
Great.
Okay, great. I talk fast. The last thing I wanted to emphasize, and without promoting my role too much, but the last thing I do want to emphasize is that inherent in the obligation to balance competing interests is the need to have multiple voices in rate making, right? Though a lot of communities that set rates and charges could benefit from having a consumer advocate, an intervener funding mechanism, some independent entity that is tasked with and provided sufficient resources to really scrutinize the underlying elements of a utility's rate claim. This doesn't happen in a lot of municipal water rate setting around the United States. And I think that what that means at the end of the day is that the rates and charges are, in some ways susceptible to criticism, that we don't know whose interests have been balanced because we don't know the record, we don't know who has scrutinized the underlying assumptions. And in my experience, sometimes those underlying assumptions are unreasonable. And they would actually drive up rates and charges more than necessary to deliver the service. Without getting again into Philadelphia too much, those are sort of the principles that I bring when tasked with looking at a rate increase proceeding and what I think should be the outcome when an independent rate making board, like we have in Philadelphia, makes the decision. Just and reasonable and non-discriminatory rates can support well-designed programs, and they should be found to be legally permissible. But I think we need to look at, and hopefully in the context of a model state law, start framing the discussion in the context in which it happens. And that's really in the context of a rate-making proceeding. And that's where I think at the end of the day, there is some give and take, but there's also a lot of opportunity. There's opportunity for advocates for different consumers to be heard, to bring in their own qualified experts and consultants, and to promote access to affordable water that can allow the utility to really fulfill its obligations to the entire community and not just those who can afford to pay for service.
Robert, thank you so much for those thoughts. That's really, really interesting. Well, our next commenter has bravely agreed to be the only non-lawyer on a panel of lawyers. And I assured her we would be kind. Over to you.
Okay, thanks. I do have some slides, so we can pull those up. I'm not a lawyer, but I do play one on TV. So the National League of Cities, for those that don't know, we're a membership organization. We represent 19,000 cities, towns, and villages across the country. The city itself, next slide. The city itself is the member. So we work with mayors, council members, and city staff. And I know there are some local officials maybe in the room or online, so hello. And then we have 49 state municipal leagues, unfortunately not for us, Hawaii. So I know there are some state folks in the room too, so you probably have your own connections with those state municipal leagues. We can go to the next slide. So I always like to start out like with a big picture of what's going on in cities, towns, and villages across the country. We do 2 reports every year that kind of highlight the local priorities and then the fiscal ability of cities to meet those priorities. So the first is our State of the Cities report, and this comes out in the summertime. I guess you'll share the slides. These are links to the reports. You can access them online. But the State of the Cities report looks at mayoral state of the city addresses, which usually occur between like January to April of a calendar year, and classifies what are the top priorities, what are mayors talking about for their communities. So no surprise, in 2024, economic and workforce development was the #1 priority, followed by infrastructure, housing, public safety, and public health. Energy and environment was 6th on that list. So the infrastructure category, which again was 2nd, really includes climate resilience for infrastructure in the face of extreme weather events, but also includes parks and trails and bike paths, and green infrastructure, green spaces, as well as traditional infrastructure, including water, and specifically, we heard a lot about stormwater management from communities. And then there's the importance of accessing federal infrastructure funding dollars that was talked about in mayoral addresses, and that obviously makes sense with the bipartisan infrastructure law, providing all of those opportunities for local governments. The second report is our city fiscal conditions report, and this comes out in October of every year. This year will be our 40th year of doing this report. It provides a comprehensive analysis of fiscal health of local governments, and it looks at actual budgets and revenues and expenditures, as well as projected. And it really, again, just gives that insight about the fiscal ability to meet the priorities of a community. So what we've seen is that cities are back on their feet, and they're being cautious about their future as they're really approaching the end of their ARPA funds, American Rescue Plan Act, and seeing the end of the infrastructure grants, although of course we hope those are reauthorized. But city health has rebounded. There's healthy outlook on the fiscal side. Rainy day funds have helped cities expand their general revenue expenditures. And so they're doing this because property tax and sales tax receipts have increased. Public safety is the largest category of general fund expenditures. But the real takeaway is that 64% from the fall 2024 surveyed said that they are better able to meet the financial needs of their communities in 2024 than they were in FY23. So we can go to the next slide. And so then similarly, I just want to give the big picture about the challenges that local governments are facing when we're talking about water infrastructure. We've talked about some of these already. Aging infrastructure, some of it's, 100, 150 years old. It leaks, it breaks. Unfunded mandates, we're seeing more of those coming down from state and federal governments. Often there's limited fiscal resources and state preemption on local ability to raise revenue. Affordability and equity, of course, is what we're really talking about today. The disproportionate impact that water bills have on low-income households. Climate change is another one, whether you've got too much water or too little. We know it's going to really change. The water infrastructure challenges create new challenges around water quality and availability. Pollution and contamination, lead, PFAS, nutrients, pharmaceuticals, what have you. Really, local governments are charged with providing clean water to their residents. And this often means that they're investing in capital projects and building new facilities or improving existing facilities with new technology. Aging workforce and workforce diversity. A large segment of the water utility workforce is set to retire, eligible for retire in the next 5 to 10 years. That far outpaces, other sectors. And many communities are looking at investing in apprenticeship programs and getting new workers into that pipeline. And then finally, cybersecurity threats. Drinking water, wastewater systems are critical infrastructure, and a cyber attack, we've seen these in small, medium, large cities across the country, could have serious repercussions on service, providing damage to critical infrastructure, loss of life, what have you. We can go to the next slide. So I have a few slides and thoughts. I really appreciated the article, and I just wanted to put some thoughts down here that build on National League of Cities perspective in relation to that. So first, I want to say that it was last December that EPA released a report on water affordability needs assessment, which I think was the first time they have done that. It noted that unaffordable water bills are widespread and a growing issue, and indicated up to 19.2 million households lacked access to affordable water service. The report makes recommendations for reducing unaffordable access to water, such as creating a federal assistance program, but it does not consider the impacts that EPA's own rulemakings have on the cost of local drinking water services and affordability. This includes PFAS, lead, and copper. We mentioned the low-income household water assistance program. It was really designed as an emergency relief program in light of the coronavirus pandemic. And it has since ended. The funding expired. It was funded twice in 2021, but it has since ended. But two other things that I think really get to the heart of the problem is integrated planning and financial capability. This was discussed a little bit in the article, but National League of Cities, our efforts go back to the early 2010s, where we were working with local leaders and EPA to develop a framework to provide flexibility for local governments to make progress on their Clean Water Act requirements, but doing so in a way that would provide more flexibility and kind of be able to meet their most pressing health and environmental needs first. They wanted to be able to utilize green infrastructure as a more cost-effective way of managing wet weather events. And so from 2010 to 2012, we were working to develop and implement this integrated planning framework to give local governments more flexibility to sequence and schedule their projects to meet Clean Water Act requirements, do so in the way that makes the most economic and environmental sense for the community. This was a huge step forward. It was actually codified by Congress in 2019. And it was missing a piece of the puzzle though. So then we began a new conversation with EPA on financial capability to really determine what a community and residents can afford when it comes to meeting consent decrees and the requirements of the Clean Water Act. So this dialogue began really in 2023 to clarify that when developing these schedules, the general idea is that local governments can put forth not just your standard financial documents, but social economic factors such as education or employment or population growth or decline, to help determine what the community and the residents specifically can afford when developing those compliance schedules. So we can go to the next slide. And then I just wanted to share a little bit about two technical assistance programs that NLC has provided to cities. We worked with a number of cities to address specifically water utility payments, but also municipal fines and fees in general, to really get to that heart of making sure that the residents can afford a lot of the services that cities are providing. So we know city leaders, see the economic impacts of fines and fees and the debt that it has on low-income residents. They've implemented strategies to address these negative impacts. And so the first cohort was called Lift Up, and that was specifically about supporting cities with their water utility payments. We had 5 cities in this network: Houston, St. Petersburg, Florida, Louisville, Newark, and Savannah. It helps cities connect utility debt collection practices with financial empowerment services and basically improve the family's overall financial well-being. And then building off that work that was specifically on the focus on the water utility side, we had 2 cohorts of cities in a program we called CAFI that drew on those same lessons, but expanded the outlook to a broad range of municipal fines and fees. So we had several cities from the recent cohort looking at all kinds of fines and fees, from pets, code enforcement, driver's license, property taxes, and whatever. So this was really about coupling not only looking at those debt payments, but with actual financial planning to support residents and households in the long term. We can go to the next slide. And then I just had 2 examples, just from the cohort, Durham, North Carolina, and Lansing, Michigan. For Durham, they were collecting millions of dollars in utility fees for late fees and disconnection fees. They were targeting residents for this program that had certain amount of disconnection notices, and over a course of a year had high bills that hadn't been paid for 100 days or more. They enrolled these residents in financial counseling to look at their overall family budget planning and some other credit card analysis and stuff like that. And same with Lansing, but again, it was really just helping get residents set on a more sustainable financial path in general. And then next slide. And then lastly, I just want to say I appreciate this gray area of utility law. I just wanted to highlight 4 other areas where there's a gray area as well. 2 of these, the first and the last, we've actually already achieved, so we can cross those off the list. But early last year, when this directive for lead pipe replacement was really coming down to cities, we had to get an IRS ruling that said if a local government replaces the private side lead pipe replacement, that's not taxable income for residents. That was really this burden of local water utilities potentially having to issue 1099. So whole range of issues there. So luckily the IRS clarified that it's not taxable income. But same story with water conservation. If you're doing, LOFO shower head rebates or something like that, we don't want that to be considered taxable income too. It's a gray area. Removing regulatory barriers to allow municipal bonds to be used, again, for lead pipe replacement. It's possible you can do that, but this regulatory paperwork you have to file is a disincentive. And then similarly, you can use debt financing for green infrastructure, but it was a gray area. So we worked with government accounting standards body to basically clarify, no, actually you can use municipal bonds for green infrastructure. So a few other thoughts for consideration there, but appreciate it.
Well, thank you so much. And I just think it's helpful to have that context and just to keep in mind the incredible range of issues that cities are dealing with and the financial limitations as they try to prioritize. And I suspect our next commenter is also going to ground us in reality a little bit in terms of what the people who are actually operating these
Sure.
facilities have to do.
Well, thank you. Thank you all for coming and allowing me to participate. First of all, congratulations to Professor Murthy on a very well done article. I probably have a few things, questions about it and maybe even some reservations, but in the main, it was a tremendous piece of scholarship. And thank you for that. And Carolyn and I are probably on the same page for a lot of issues. We work hand in glove with all the water associations, including Carolyn's group. And in fact, Water Week is coming up where we all come together. We bring 200 of our volunteers just for AWWA in town to hit the hill. We don't say storm the hill anymore. But, and all the other associations, you're involved with that, aren't you? And for instance, we've got a position paper and we all signed off on a low income water assistance program, which, you know, is an important thing to remember because let me come back to this. When you go into a grocery store, suppose you're a poor person, that lowest quintile, forget about MHI, which is a defunct concept and EPA's got to let it go. But in that lowest 20% of the income level, and you go buy some eggs, you don't get a discount on eggs, do you? But you may have food stamps or a SNAP card, okay? If you go to rent, to buy a home, the bank isn't going to, you know, reduce your interest rate, but there is FHA guarantees and loans and subsidies. If you get an electric bill, that bill, I don't know, I was interested in the first panel. I'm not an expert in the electric sector, but you have a LIHEAP program, low income heating and assistance program. No such program, and Carolyn was alluding to this, no such program exists for the water and wastewater sector. That's why we're all united on that. And that's too bad because the danger, and I'm not saying it's a real problem, but it's an issue that worries me is distorting the price signals, muting the price signals may mislead the community and the customers and everybody else as to what it takes to capture, treat, and deliver clean and safe water, or conversely, dispose of wastewater. I admit, I'm a little hung up with this issue of pricing. One of my sort of epiphanies, intellectual epiphanies, was reading a famous essay by Friedrich von Hayek, who won the Nobel Prize for Economics. He wrote an essay for the American Economic Review in 1945, before I was born even, the uses of knowledge in society. And essentially, he's talking about the complexity of delivering a good or service, or in this case, we're talking about water, water services, as well as water as a commodity. And this idea that price was the one mechanism, delivery mechanism for information that people could then summarize all this many multifaceted information and disparate actors and players. And he said, I just quote from one paragraph. I wrote a lot more, but I won't try your patience. Fundamentally, in a system where the knowledge of the relevant facts is dispersed among many people, prices can act to coordinate the separate actions of different people in the same way as subjective values help the individual to coordinate the parts of his or her plan. We have underpriced water since municipal water began. That is the truth. When I got to EPA in 2001, we were preaching full cost pricing and people became unglued, especially people from the wastewater system, because they've been conditioned to a subsidy mentality through the Clean Water Act grants that were supposed to be ongoing. And eventually that program got converted to a revolving loan fund, which is now under stress due to earmarks. But the fact is, I remember GAO did a report on pricing and we were way under where the Europeans were. It was only 2 to 3% of income. I know now with inflation and with all the other problems in society, the economic issues and the sort of the bifurcation of the income levels, we're facing a new reality, hence the relevance of Professor Murphy's paper. So all this is to say that we would prefer in an ideal world that we have a subsidy program separate from something that distorts pricing. Most of my work in the last 30 years has been trying to get around the fact that most of the municipal water sector is politically driven. it's not treated as an independent enterprise. There are great examples to it. DC Water being the great one. DC Water used to be embedded in municipal government. It was a Marion Barry jobs program. You remember, anybody here old enough to remember Marion Barry? Went to jail for a while.
Say what he said.
And then there was a revolt of the congressional delegations in Maryland and Virginia, and they pulled it out of city government, set up an independent commission. Today, they've got 4 or 5 different customer assistance programs. They're raising rates at about 8%. They're doing green infrastructure. They're doing big tunnels for combined sewer overflows. It's now really one of the more outstanding water systems in the country. There's other models too, and I think we sometimes get bogged down into this binary debate between privatization and public, when there's a lot of models on a continuum that create distance from the electoral process and the political masters who view rate increases as a tax increase and therefore politically a root canal. So some of us are kind of suffering the scars from trying to get the rates up to something that looks like is aspirationally full cost pricing. The M1 manual from AWWA that the professor put up there is a major effort by something called our Rates and Charges Committee. And I maybe would like to work with Professor Murthy of getting you kind of exposed to people who are actually doing the rates, not just lawyers who aren't, but there are lawyers litigating rates. But in terms of the day-to-day, working with utilities, and there's a big debate about these issues. These cross subsidies and everything else. And a lot of people are very scary of going down the road of Philadelphia, et cetera, et cetera. And let me say, I admire Philadelphia Water for so many reasons. Their work on green infrastructure, integrating into the combined sewer overflow program. I was a big supporter of that when I was at EPA. Randy Heyman, who runs it, is from my hometown of St. Louis, used to be general counsel at Metropolitan Water Sewer District in St. Louis. So they do great work. But what do they call it? The TAP program?
Peer assistance program.
Yeah, that's a result of a particular set of social, political, and cultural circumstances that whether or not that line travels well is a question. So my bottom line position, and I won't dwell on this, is I think the idea of a model statute can have merit, but I think it ought to be one that sort of enables flexibility and experimentation. And there's a lot of different approaches without mandating something like the TAP. And if you want to see a critique of the TAP, I could go through the critique, but most of the critiques I'm aware of are by Professor Manny Teodoro, who's a well-known expert for the water sector up at University of Wisconsin. And a couple of the problems were administrative costs. I mean, you had that, 12 to 20 people running it? Anyway, the administrative, at one time until about 2018, when they changed things, they were spending $300 to deliver an average subsidy of $600. If a not-for-profit had that kind of overhead in any state, they'd probably have the attorney general of the state knocking on their door. The other thing is that they've had to raise surcharges, volumetric surcharges to pay for the program. Again, nothing's free, no free lunch. The problem is, given the lower level of participation, you end up making the situation worse for low-income non-participants. And I believe 50% or so of the people in Philadelphia are renters. I'm not saying these are deal killers. I'm not saying they shouldn't be tried, and they've made great improvements. But what they were able to do, the problem was getting the data, and they couldn't do the data analysis very well originally, and they had a really very low participation, way less than half. Fortunately, or unfortunately, depending on your point of view, Philadelphia has a municipal income tax. Very few cities in America will have that, praise God. But they had the data, and then they finally got it right. And so they've improved the program. And in Manny Teodoro's words, it's gone from really being indefensible to being defensible as a program. So it's an option. And I think I will say this, I commented years ago, I lived in 5 different cities, and in every one, the utility had a low income assistance program, voluntary, to put a check in the envelope and send it in, or they work with the local United Way. None of the water systems I've been a customer of have had that. When EPA did the program, I think you referred to it, both of you referred to it, the 2017 study of customer assistance programs, they said about 30% of the surveyed utilities had a CAP. The word I'm getting out of EPA, they're going to update the study, is that look like they're getting close, over 45, not yet 50%. So I think it's growing as a movement in the water sector that we know we've got to deal with this low income issue, especially that lowest quintile. And so, as I say, I think there's room for more efforts, more experimentation. Philadelphia might be the way to go. There may be, in Washington DC does several things. At least, and this goes back a few years when George Hawkins was there. I haven't updated this, but they have, of course, what do they call it? A stepwise billing where you get the first quantity free or almost free, not free, but you know, the very low rate. They have separate discount rates depending on if it's a stormwater program, et cetera, et cetera. They've got a program for lead service line. I think they do lead service line replacements for free. So there's a lot of ways to do it. You know, California American Water, an investor-owned utility, has a great program out in California. So let's let 1,000 flowers bloom. Let's see what's there. So maybe a statute that enables it, this kind of experimentation would be worth considering. So I'll stop there. Thank you.
Great, thank you so much. So we're going to move now from our environmental experts to our own model law expert.
Thank you. Thank you for giving me this opportunity to say a few words about Professor Murthy's terrific article. When I say terrific article, you should know I'm a labor lawyer, and everything I know about water utility, I learned from the article. I'm here though because of the suggestion at the end that there ought to be a model law, there ought to be a law, and that the Uniform Law Commission ought to do it. And I've been deeply involved with the Uniform Law Commission. I do have a PowerPoint. Yep.
Albert.
So I have a picture on the front of my PowerPoint, and I thought about what I should do. I'm from Nebraska and with water, so I should do something about Nebraska water. We're sitting on top of a Great Lake, the Ogallala Aquifer. It's about the size of a Great Lake. It's pressured, but mostly in the south. We have a lot of year of droughts in Nebraska. That surface water, we have a lot of water and we use it. The other thing, we have I think the greatest water event anywhere ever. And it's happening right now where 500,000 cranes are on a 10-mile stretch of the Platte River. They come from all over Texas and northern Mexico and Hourglass. They go to this 10-mile stretch for a couple of weeks. And they go all over Canada. It's an amazing sight. You should go. Then my next slide was like when I got guilty about being in Nebraska. I thought there's some utility slides too. Next slide. I'm going to talk about three things: what we are, what the Uniform Law Commission is, our process on deciding projects and drafting state laws, and then the potential and problems for the ULC in dealing with Professor Murthy's proposal. Next slide, please. So here's who we are. We have a long history. We were founded in 1892. We're a quasi-state entity. Each state plus District of Columbia, Puerto Rico, and the Virgin Islands are members. Primary funding is from the states. I think the best way to think of us is a cooperative. States pool their resources if there's a common interest to have a good law developed, and we're experts at developing good laws. Each state determines who they send and how they select them. There are about 400 commissioners. We're all volunteers. None of us are paid, and we're all lawyers. A lot of famous commissioners. Some of I always, again, I'm from Nebraska, so I mentioned Roscoe Pound. A lot of famous names there.
Rosser on Moritz, how can we forget?
When I speak to academic crowds like this one, there are people probably Abby Gluck and John Weinbein from Yale, or commissioners, Curtis Wrights from Penn, Rob Sitkoff from Harvard, Bob Stein from Minnesota. We have Supreme Court justices from Texas, Washington, Oregon, probably other places. We have many state legislators. We've had many enactments, over 7,000 enactments over our history. Very modestly, I would say I don't think there's an organization, any other single organization that's had a greater impact on state law than the Uniform Law Commission. Students are probably studying the Uniform Commercial Code, right? Which is fun. Oh, I had one aside too for the Vanderbilt students. I was the chair of the last, I think, site visit team from the ABA to decide if your accreditation should be renewed. So you should thank me for that. It was
because we pass with flying colors.
You have such a
powerful role.
Such a terrific law school.
Okay, next slide, please. Oh, I should say a couple other things. Yeah, next slide. Here's our process. So the first thing is incubating. We have kind of committees of our own that monitor state law in areas where we have a lot of success, like commercial law and family law and health law. We do this quite a bit, which is my purpose in being here, to comment on the paper, but also to encourage you to think about coming to us for this. Most of our ideas come from commissioners. I've been giving, have given seminars at law schools to try to encourage faculty to give us ideas, and it's been less productive than I would have hoped, actually, because a lot of law review articles end with this, there ought to be a law, and I want them to think of us when they do that.
We're gonna change that.
Okay, I hope you do. I hope you do. We also get proposals from high school students, from prisoners. Prisoners spend a lot of time thinking about law. So we get ideas from all over the place, and we accept them as like 2 paragraphs or 20 pages. When we get a proposal, it goes to the scope and program committee. That's why I'm here in the chair of that committee right now. It kind of sets the program for the ULC. And we decide whether we need to have a study committee. Study committees take about a year. They're deciding if it's worth the extra resource and time to actually draft a law. Study committees are completely remote. There are no in-person meetings. After that, if we decide that it's worthwhile, we move to a drafting committee. Drafting committees take 2 years typically. There are 2 readings, and when I say readings, I mean literally these statutes are read in a meeting in front of 250 lawyers and parsed word for word. This 2 years is a plus and a minus for us. We produce very, very good products, and we do it very, very slowly. So we can't jump onto hot topics. And then every commissioner makes a commitment to try to get our acts enacted into law. And we also have a staff of 10 or 15 lawyers, which is pretty interesting work, students, if you want to do it in Chicago, to work on enactments. The median time between when we promulgate an act and when it's enacted in the state is 3 years. But sometimes it takes a long time. Kansas enacted our Declaratory Judgments Act in 1993. It was promulgated by the ULC in 1922. And then that -2 is there too. Some states just can't wait. We have one in process and they enact it. And so that's Kentucky. Kentucky evidence rules. Nebraska did that with the latest, I don't know if you're aware of the Article 12 UCC amendment with crypto and stuff. We couldn't wait, so we jumped the gun on that. So that's our process. Next slide, please. So these are a little small, but you'll have this available to you and you can look at it. These are our criteria for selecting acts. One, of course, since we're the Uniform Law Commission, is how widespread the adoption would be. If we think there's widespread adoption, that's a plus, big plus. I think of us as the kind of modestly uniform act. If you really want a uniform act, there's federal Congress over there, right? So we are uniform with adjustments, right? We try to respond to needs in the state. If there are newly emerging areas, we see that as a plus where we can maybe shape the law. We are, even though the words are not so great, we're a states' rights organization. We try to preserve the authority of states in areas where they traditionally act, like commercial law, like family law. So we do that. The last one is important. It's kind of a bad word these days, we've discovered, but we're nonpartisan. So we don't do guns, we don't do abortion, we don't do things that are going to be highly have a high political valence like that. Next slide, please. So here's my kind of reaction to Professor Murthy's specific proposal, given who we are and what we do. She recognizes in her article that we should probably be thinking about a model act rather than a uniform act. We have those are well known within our organization, but not generally. Model acts are what you would expect. They're a guideline and states are invited to amend them. Uniform acts, we want them to be like that, like the Uniform Commercial Code. It's very important for things to be uniform across state lines. Professor Murthy recognizes that this kind of area is so varied that probably a model act would be the appropriate one. Another issue for us would be how amenable this is to a state statute. That's what we draft. Sometimes we drift over into court rules on subjects that tend to straddle the legislative judicial divide, but we don't do ordinances, we don't do regulations. That may be an issue in this context. Another concern for us is constitutionality. We're proud of our history of never having one of our acts declared constitutional. We had one before the Supreme Court we were worried about a while ago. Unconstitutional. Yeah, sorry. Thanks for the correction. That record will probably be broken someday. This act would be interesting because it may be one where we'd have to have options and direct some states away from certain provisions or something like that. I'm not sure we've done that before, but it would be something we might have to consider. Professor Murthy mentions in her article that maybe we'd want to have a purpose clause. We have a rule against purpose clauses for reasons I won't go into, so that would be an exception we'd have to make.
You have to now explain why.
The idea is we establish the rules and we don't want to have any ambiguity between the rules we establish and the purpose that's announced.
Okay.
There was a long discussion about it, and you can go either way on it, but we
Yeah,
have a rule against
interesting.
it. Yeah, almost everything when we're talking about these criteria for selecting on this, like you said earlier, these are not science, right? These are criteria to think about. Finally, Professor Murthy mentions the issue of coordination with the federal government, and we've had a variety of levels of coordination with the federal government. She mentioned the Heirs Property Act, which is designed to clarify title when title is fractionalized. And the federal government put a thing into the Farm Bill that said if a state enacts our law, that's good. You'll be more likely to have farm benefits if you enact this law. So it was an encouragement. We have much stronger incentives with the Interstate Family Support Act, which permits child support agreements to be enforced across state lines. The federal government said, if you don't pass it, we're not going to give you federal child support money, which for a small state like Nebraska was tens of millions of dollars. Every state enacted it. There's also reverse preemption. So there's a electronic transaction act and a federal e-sign bill that cover about the same things, recognizing electronic signatures. And the federal act says if the state enacts our act, there's reverse preemption and the state act applies. So there's a whole variety of coordination. I'm a little wary about coordination with the feds in this space, because if we raise it, I wouldn't be tremendously surprised if they did the opposite, right? Saying states can't do it. So there is that risk as well. So maybe a model act is possible, but there are problems too. It's presented to us as being less to think about. Thank you so much.
That was really interesting. It's something I haven't really thought about much.
I just want to say two things about this panel. if I may. This is a fascinating discussion, and we'll hear more from the author in just a second. But two things that I think are extraordinary. One is this may be the first time when there's been a citation to environmental justice and Hayek in the same panel. That is exactly what we're trying to capture on some level, which is people coming from lots of different perspectives and engaging on a topic. And there's just too little of that going on.
Roscoe Pound is
well, you know what, Roscoe Pound is in the mix now too. And so that's one. The other one is much more provincial, but I would say that the author obviously has a Nashville connection. That didn't go into our thinking. You were selected despite that. I don't even know if we knew at the time that you had been a Sixth Circuit clerk, et cetera, et cetera. And now we have on this panel a Philadelphia lawyer who speaks really quickly and yet knows that it's DeKalb County, not DeKalb. And we have a non-lawyer who can say Louisville. So I just want to say thank you to Linda for putting this panel together. I think really, both intellectually and culturally, a really interesting mix here. Yeah.
Professor?
So first of all, thank you. Thank you tremendously for just the opportunity to share these ideas and to have such fabulous feedback. And let me say that, let me actually start off with what Professor Vanderberg said in his opening remarks, which he said, when you go to a law faculty workshop and they say, cut off the last bit of your article. And guess what I had? It's the new project scope criteria for the Uniform Law Commission, which is essentially the bulleted points of how I thought this could work. That got jettisoned out of the article, but I'm hoping that if this idea has legs, I can dust that back off. And so I just so appreciate this forum because for folks that, want to be thinking about new transformative ideas, but then how to take them into practice, this just seems like such a amazing opportunity. I would say that I really loved Tracy Meehan, your quote. Not sure that wine travels well. I think my goal here is to figure out what vintage and what type of grape will allow this idea to travel well. Because as Professor Wilborn said, there are challenges with bringing this idea before the Uniform Law Commission. And it's a challenge because we heard about the challenges that cities face, right? That they face affordability challenges, but in some instances, they are the ones that are in the seat of code making versus the state. So these are things that I would love to grapple with. I come back to the point that you made about just the common law duty to serve. And that is in some ways the guiding principle that maybe takes this out of the political realm, not having, I think the purpose clause was a reference to the fact that California does also have a human right to water statute. In this era, we don't need to go down that route. We can just stick with what is the basic fundamental purpose of a utility? How do we ensure a scenario where this is affordable for individuals? Recognize that actually helps our community from a public health standpoint, from the cost of sort of social costs, et cetera, that this works for cities, that this works for utilities. And I want to also highlight that out front. We have this great article that Tracy Meehan wrote from the American Water Works Association.
Thank you for citing it.
Yes, well, it's great. And I think, there's this great quote in it where you say, many state statutes require water service rates to be reasonable, uniform, non-discriminatory, or just. Often the intent behind these terms is to require utilities to charge all customers the same rate, rather than prohibiting the use of rate revenue to subsidize low-income customers. But the latter is a side effect. And the question is how do we allow for utilities to actually be able to get the revenue that they need to provide service to everyone within their operating jurisdiction, but in a way that provides for everyone to actually have access. And so I would just love to continue to work with all of you and to talk to non-lawyers who are actually thinking about how the sort of the nitty-gritty of utility rate making, and really think about whether or not over the next handful of years, we might be able to actually build a case such that this comes before the Uniform Law Commission and they determine that, yes, despite some of the challenges that were raised, this is something that has legs and that might actually help ensure that everyone actually has access to affordable water. Thanks.
Thank you. Well, we're going to start with our wonderful Vanderbilt Law students going to pose our first question. And then again, webinar participants, please put your questions in the chat or the Q&A box.
So it feels as though many utilities and the schemes that govern them are slow to evolve, but you provide some good examples of innovation like Philadelphia. How do we create an environment that encourages more utilities to innovate and try new solutions, like your proposed model law?
I mean, I think this is a great question, but one that I would, if it's okay, I would love to actually hear from some of the other panelists on, because I think you were already just citing that there's a way in which once ideas get out there, other jurisdictions begin to look at them and say, wow, maybe we could do something like that. It worked there. And it seems to be working both for the utility and for customers. And I think in that sense, the idea behind the model law here was not that you were going to put a straitjacket on any utility and force them to do this, but rather this is about removing that level of gray that prevents utilities from wanting to take the step. But I would actually love to hear maybe from you, Robert, about that, since you did provide an example.
Well, I mean, I think, I can speak to what motivated Philadelphia to sort of take this big step. And it was really the accumulation of debt. It was the accumulation of debt that was not going to be repaid in particular portions of the city where it really did sort of constitute a sort of a political reality that was just not, not something that anyone could accept. In a single year, Philadelphia's lean residential water debt went up by more than $30 million, and this is in 2014 actual dollars. So let's go back to today. We're talking about a massive accumulation of debt. And so we did look for available models. I mean, we looked to the 30 years of experience at the Pennsylvania Public Utility Commission with customer assistance programs for electric and natural gas utilities. And there have been multiple studies of these types of programs that have shown their effectiveness. And what they really do as a matter of policy is take what the unaffordable portion of a bill that a low-income household won't be able to pay, and they direct it elsewhere. So it's an alternative collection practice. I mean, I think the more that we see in municipalities adopting different rate structures and programs, we get more ideas about how it could fit in another community. And and to Mr. Meehan's point, I mean, I don't take a one-size-fits-all approach. I've testified in favor of program designs that are not percentage of income programs. But just to respond really quickly to the administrative cost critique of Philadelphia, it's wrong. It's based on the premise that certain consultants who were hired to do a broad range of things only worked on TAP. And it disregards a fundamental principle of utility law. Again, I didn't get to, but I want to just get to really quickly. Someone who qualifies for multiple rate structures is entitled to the one that's most affordable to them. So in Philadelphia, when someone applies for any assistance, they don't just apply for TAP. Their application is an evaluation of what's the most affordable alternative for them. So that includes the senior discount, it includes long-term repayment options. It does include TAP. But the administrative cost critique is premised upon that entire unit that handles all assistance programs being attributed entirely to the tiered assistance program, which is absolutely incorrect. I'm glad that Professor Theodore has come around, but I think what he put out there was a bit dangerous for purposes of evaluating how these programs can work. So I would encourage communities to look at other scholarship. Professor Murthy and I both communicate a lot with Roger Colton. He's put out some really instructive materials, and I think there are lots of examples to borrow from for struggling communities.
Well, I'll add that, cities do want to innovate. I mean, we often say that they're laboratories of innovation, but they are risk adverse. And if there's any area of legal uncertainty, it's likely to lead to inaction. But there's a lot that can be done with data and new technology that can lead to innovation at the local level. If you're talking about, sustainability or water utilities, that will make services more effective and efficient for both the city and have the benefits for community members as well.
I guess I'm pretty reductionist. To me, the two biggest things that need to change in the water sector is we've got to get more distance from electoral politics. It's a socialist system, but at the municipal level. And so as I mentioned, a rate increase is a political decision by people who are looking to run for re-election. There are many models. Boston is operating under Massachusetts law, has distance and an independent commission, very well run. I've cited DC Water. Denver Water is a separate commission. Louisville is a separate corporation owned by the city, and they write a nice big dividend check back to the city every year, which kind of encourages independence and run as an enterprise. Investor-owned utilities, some of the best utilities in our membership. They're a small minority, like 15% of our membership. We have 4,400 utilities, but here's a great irony about investor-owned utilities. They never sweat when we're, arm wrestling with EPA over a new regulation and all that. They're very unengaged, and they're great members. I'm not, but they don't care. They said, go ahead, hit us with LCRI, hit us with PFAS. They just go to their Public Service Commission and they get a rate increase on ROI. Whereas our guys have to go in and beg and grovel to mayors and city councils and public hearings and all that. So I think anything that would create that distance and allow rates, without more resources coming into utility, there's a lack of incentive to do things like customer assistance programs.
Oh, I want to follow up on your first point, and then go to the audience, but you mentioned, and I can't remember the exact words you used, but you essentially said, we don't pick topics that are really politically divisive, right? And this is a non-statistically significant sampling. I did not look at all 7,000, but there are not a lot of environmental laws in there, right? And so I was just wondering if you could comment a little bit more on, well, what could work in the environmental context, which is,
We
you
do,
know,
we
so-
do have a couple now that might be semi-relevant.
Yeah, yeah.
So one, we have a study committee now on a commercial law framework for voluntary carbon credits.
Oh.
Which is in the environment, and the idea is trying to develop a framework for measuring them
Yeah, right,
and valuing them and so on. That's a study committee. I should mention, these study committees, we want everybody to be involved. We want every stakeholder
Yeah.
in the room because we don't want to be surprised later. We want to have.
Exactly, yeah.
We're also have a study committee to revise the model state administrative procedure act. Turns out almost every state administrative procedure act is based on our models. There have been 5 or 6 iterations. With the last iteration was 10 or 15 years ago, and some of you may know some stuff is happening with administrative law. So that's a thing.
Okay,
So there are
yeah, interesting.
direct environmentalist hard for us, I think.
Yeah,
because
no,
of
I
what
can
you're
see,
saying.
I can
Yeah.
see that, and that's to your point of making it, a cost issue.
And on that note, if I could just
Mhm.
real quickly suggest that maybe Professor Murthy and I should think about a future paper that would be almost all theory, but that would look at this question. Tracy talks about the value of distance from the population, and of course, the unitary executive notion is out there. Justice Kagan at 1 point said we're all unitary executives now. I have a piece with Lisa Bressman in the Michigan Law Review that looked at White House involvement in EPA decision-making and concluded that it wasn't always as benevolent as all the people who were in the White House counsel's office always said it was. And so one interesting question would be on a more theory-driven basis. Are there ways we can think in a more sophisticated way about the relative role of responsiveness to the electorate versus not as it relates to the environment?
Could I
Yeah,
respond?
please.
I'm talking about distance from electoral politics, not unaccountability.
Yes,
And
agreed.
most of the models I just cited, Louisville's a little different, although I think their board has representation appointed by the city, or the city politicians. But DC Water, Denver Water, the jurisdictions pick the commissioners,
Right.
who are the governing body, and they have set terms. They don't run for election. They can't just blow off the
Right.
mayors and the county, but they have basically some protection and can think more about the enterprise rather than the reelection.
And those are the kind of distinctions I think we would need to be able to explore a little bit more, because otherwise people tend to be pretty simplistic and they assume it's an on-off switch.
And I want to mention one thing from a webinar commenter, because we've been talking about sort of like what resonates, what's going to work in terms of the framing. And this participant asked whether any panel member could comment on the existing relationship between public health offices and the passage of laws for income-based utility billing. For example, do epidemiological studies assessing effects of water quality on health outcomes impact the ability of passage of these bills or assess effectiveness of these bills after implementation?
I hope not.
I mean, I can speak just very briefly to the fact that there is some research, some preliminary research associated with shutoffs in particular, and as a sort of a symptom of what are the social costs associated with someone's disruption of water utility service, and there's some literature on that. I don't know that necessarily feeds directly into sort of the regulatory mechanism of establishing rates and charges. It's an interesting question. But I think if putting it in sort of the context of my earlier comments, fulfilling the duty to serve, I think sort of threads the needle between the two, right?
Yeah, no, that makes a lot of sense. Lunch is next, and I'm sure people are hungry, but let's take one question from the audience, and then I hope you all can hang out a little bit and chat during the lunch break. Any questions before lunch? No one's gonna raise their hands because it's almost lunchtime.
This one. Go on back.
You got one.
Yeah.
So I just want to make the clarification around the duty to serve. As one of 2 legal scholars that has done a deep dive in this in the last 30 years, there actually is a longstanding common law exception around the duty to serve for payment specifically. So I would actually be interested in perhaps, one of the ways that we need to think about this is we may need statutory changes around the duty to serve if we actually expect it to cover non-payment. Because right now, if you can't pay, that is in all common law sections around the duty to serve, one place where you can't be shut off.
Could you provide us all with a link to your article?
Yes,
Maybe put it
so,
into a.
it's called unservice. Actually, looking at the duty to serve in light of climate change.
Yeah, but can I comment on this? I have never heard the duty to serve brought up in any venue in the municipal water sector in 30 years. Never. And my assumption is the duty to serve probably is applied mostly to private entities that are regulated monopolies, not municipal systems, who are in most states except Wisconsin and a few other exceptions, completely out from under the PSC PUC umbrella. And it's left to the community. And this is the good and the bad, you know, the local mayors and whatever to make this. So I think it's more a ban on exclusion by a private party of citizens. Whether it's as applicable, I'm not an expert, but when I've listened to your discussion, maybe it works in Philly, but.
Well, let me, I mean, I'm not saying that the common law requires every utility to provide service forever without regard to payment. But the sort of core notion of the duty to serve has to do with connecting all patrons within a utility service territory and continuing the service without without unreasonable interruption. But if you also apply on top of that, Coker v. Guarino, the Memphis Light and Gas v. Kraft, you will find very clearly that there is a due process right to contest any termination of service, right?
Are those involving a public entity or are they all? investor owned?
Memphis Light and Gas, yeah, this was Memphis, yeah, and Coker v. Guarino is Philadelphia, 1976.
The city water?
Yes.
Oh, okay.
So, I mean, yes, there are certainly conditions, and we experience them very frequently in Philadelphia, where people are shut off because of their inability to pay. But tracing that duty back, and yes, it does come primarily from investor-owned utilities. As a sort of a principle when approaching the notion of what a low-income affordability program functions to achieve in the context of whether it's an investor-owned or a municipal utility, from my perspective, it is continued service. The idea that the utility can continue to provide service to a low-income customer who couldn't pay full rates in exchange for an affordable rate. So that's the connection that I'm making there, but I take your point.
All right, thank you for an excellent discussion.
My name is Jay Eisen. I'm a third-year law student at Vanderbilt University Law School and an ELPAR articles editor. So for this panel, we'll be discussing the article Transitioning to Regenerative Agriculture, One French Fry at a Time by Professor Alexia Brunet-Marx. So Professor Alexia Brunet-Marx is a food systems scholar with expertise in law, agricultural economics, and international business. At Colorado Law School, she is a full professor and serves as Associate Dean for Academic Affairs. Professor Brunet-Marx received her JD from Northwestern University Law School and her PhD from Purdue University in agricultural economics. Her award-winning research on relevant food systems issues of our time is both transnational and multidisciplinary. It has been published in leading law review journals and books and featured in leading media sources. Before joining legal academia, Professor Brunet-Marx worked as an economic risk analysis and modeler at the U.S. Department of Homeland Security. She began her career as an entrepreneur in a global trade venture in Poland. And then our first panelist, Carrie Apfel, is the Deputy Managing Attorney of the Sustainable Food and Farming Program at Earth Justice, developing legal strategies to promote a safe, just, and climate-friendly food system. Some of Carrie's recent work has focused on increasing transparency into the industrial agricultural system and challenging the efficacy of crop-based biofuels and manure biogas climate solutions. Prior to joining Earth Justice, Carrie was a partner at Jenner and Block. There, she worked on a class action on behalf of Native American farmers and ranchers, challenging discrimination in USDA's Farm Loan Program. The case obtained a $760 million settlement. Carrie clerked on the Fourth Circuit and graduated from University of Virginia Law School and Duke University, both with many honors. Our second panelist, Bonnie McGill, is a senior climate and ecosystem scientist at American Farmland Trust. She works to quantify the climate impacts of soil health practice implementation in collaboration with scientists at the U.S. Department of Agriculture, universities, and private companies like Regrow and Indigo. She also acts as an honest broker of information, helping farmers and organizations make sense of agricultural carbon markets. McGill earned her PhD from Michigan State University, and she lives in Pittsburgh, Pennsylvania. And our final panelist, Brad Redlin, is the program manager for the Minnesota Agricultural Water Quality Certification Program and the Soil Health Financial Assistance Program. He works in coordination with the Commissioner's Office to lead and partner with various state and federal collaborating agencies. Brad also previously served as chairman of the Washington, D.C.-based National Sustainable Agriculture Coalition, as a member of the Agriculture and Wildlife Working Group for Federal Conservation Policies, and as a member of the Mississippi River Collaborative's Federal Farm Policy Working Group. And with that, I'll turn it over to Professor Brunet Marks.
Wonderful. I'm Professor Alexia Brunet Marks, and my paper is Transitioning to Regenerative Agriculture, One French Fry at a Time. I am so thrilled to be here. It is such an honor. My little paper was selected. I'm very, very excited. So thank you to the journal editors, co-panelists who are so distinguished, and I'm so grateful they stepped in to just give us their time. And to our audience, both in person and virtual, and thank you all for your interest in this topic and for sticking around for the after lunch session, right? All right, next slide, please. So on the next slide. So the top two photos depict our new normal. So a world where extreme weather events are common, where nearly all crops are grown and raised in the United States face extreme climate stress, and where emissions from animal ag and current farming practices contribute to climate uncertainty and rising uncertainty. In the bottom left is a tweet from New York Attorney General talking about suing JBS, the world's largest beef producer, for misleading consumers by saying JBS is committing to be net zero by 2040. She questions how a giant meat producer who is expanding its cattle operation can say such a thing, don't you? The last photo, bottom right, invites you to imagine a future where multinational companies commit to transformative change in the food supply, from conventional ag to regenerative agricultural practices, or Regen Ag for short, that sequester carbon and are capable of reversing climate change. Next slide, please. So I focus on big food. How many of you have seen this picture before? Like, everybody raise your hands.
I'm fascinated by it.
You haven't seen this? Oh, this is like the first day in my food law class. Right?
We need to take your food law class. Yeah.
So I'm at least in my most recent writing in the last 5 or so years, I've been focusing a lot on big food as a transformative change. So I focus on big food for the scale of transformation potential it represents. Big food is a term used for consolidation in the food industry today. Depicted by this figure, you can just see that 10 multinational food companies like Nestle, Kellogg's, Danone control most of the global food supply. Many already invest in regen ag practices. 58 of the top 100 food companies in the world have regen ag products to sequester carbon, either as small pilots by meeting specific acreage targets or by tying them to larger business strategies. Many are experimenting with carbon offsetting, insetting, and building strategic alliances, showing that MNCs can play a role in systemic transition away from soil degradation towards soil health and ultimately carbon sequestration. This slide, by the way, it is the big 10 food companies, but you can make another slide. There are other slides that represent like the big, fast food giants of the world or grocery stores of the world, because there's consolidation in the food industry in general. This is just on the production side, what I'll be talking about. Next slide, please. So I start with this. And so this is the question that I pose. What if McDonald's in the paper, the one French fry at a time, right? What if McDonald's, multinational food giant, had an opportunity to source its French fries from farms fully committed to using climate-friendly agricultural practices like regen ag? Should McDonald's adopt this practice? Can McDonald's adopt this practice? So McDonald's is a public company subject to SEC and ESG reporting, and climate change commitments are scrutinized by public and private entities. It also creates and emits greenhouse gases, making it a target of international and domestic efforts to reduce greenhouse gas emissions.
And many of McDonald's competitors are also setting net zero emissions targets. Now, French fries on the McDonald's menu are just one example. It might be just a catchy one, right? But many others come to mind, like breakfast cereal from General Mills, Cascadian Farms brand. Maybe you've seen Regen cereal, or frozen pizza from Nestle's DiGiorno brand. I had a DiGiorno like a couple weeks ago, and on the box, there it was, made from Regen. I thought, this is nuts. It is really coming into the mainstream. Look at your, next time you box it, buy any box foods, take a look. Next slide, please. So back to the question, should McDonald's adopt Regen Ag? First, what is Regen Ag for those who might not have known what it is? Regen Ag can be defined by outcomes like carbon sequestration, changes in soil health, and changes in biodiversity. And it can be also described by practices. And since there's no universal definition for Regen Ag, most describe it as following these 5 core practices. 1, minimizing soil disturbance, so practicing minimal or no-till. 2, maximizing crop diversity, planting more than just one type of crop, so getting away from monoculture. 3, keeping the soil covered, using mulch and compost. 4, maintaining a living root year-round using cover crops. And number 5, integrating livestock to aerate soil, so creating poultry into growing cattle. Next, what does McDonald's, if it adopts these practices, what does it get in return? So these practices reduce 3 sources of pressure that food companies are all facing. There is number 1, pressure to reduce emissions in their food and supply chain, in the production chain. Nearly 37% of greenhouse gas emissions can be traced to the global food system, with meat and dairy companies and their cattle ranked in the highest emitters of greenhouse gas methane. McDonald's recognizes that significant portion of its emissions itself comes from its supply chain, particularly from beef, chicken, dairy, and other proteins. And it also is focusing on reducing emissions in these areas. Pressure also comes from emissions claims. McDonald's aims to achieve net zero emissions by 2050 and has been standing by this claim. So number 2, there's also pressure to adopt more resilient practices like retaining water, reducing input use. The climate is actually dictating this in a very big way. And number 3, and finally, there's pressure to respond to stakeholders who question the ESG commitments that firms voluntarily make as they try to reassure stakeholders to envision how they're coping with climate change and how financially stable their investments will be into the future. Next slide, please. So once the decision is made, what strategy would McDonald's select to make this transition? So the paper develops a taxonomy of choices, right? I think choices are great because you can't go in one direction. You can go in a couple different directions, adopt this, adopt that, build. So companies adopt Regen Ag using different strategies. For instance, McDonald's could partner with downstream suppliers to grow potatoes using Regen Ag practices in what is termed a supply side decarbonization strategy or insetting. Carbon insetting is also known as within value chain removals and focuses on curbing greenhouse gas emissions from one's own supply chain with nature-based solutions like Regen Ag, agroforestry, and others. Many view insetting as less susceptible to greenwashing compared to offsetting, which I'll talk about in a second. For example, with insetting, companies are adopting Regen Ag practices, whereas with offsetting, companies can buy offsets and call themselves more green without particularly adopting regenerative agricultural practices themselves. McDonald's could also buy carbon offsets in the carbon market. This occurs when an online broker like Nori or Indigo or Foro enables farmers to sell a carbon credit to outside entities in the marketplace. Each one credit corresponds to 1 metric ton of reduced, avoided or removed CO2 or equivalent greenhouse gas. And typically on the supply side, this is all, the market itself is incredibly fascinating. So on the supply side, those who produce the carbon credits are farmers and landowners. And selling credits in the carbon market creates a stream of payments for them. Once the credit is used, it becomes an offset and it's moved to a register for retired credits and is no longer available. And the trend is for tech companies to use carbon markets to offset their emissions. So Nori, the online broker I mentioned, buys credits on behalf of their clients, which include blockchain gaming platforms, entertainment websites, and online shopping marketplaces. And McDonald's Just to give another example, McDonald's plans to use offsetting actually. So in its aim to achieve net zero emissions by 2050, it says it will neutralize residual emissions through carbon offset schemes and other measures. But finally, McDonald's could form strategic alliances with other food industry partners by forming relationships with others with respect to training, finance, and technology. In that sense, it's just borrowing from somebody else that knows how to do something better. And so it brings them into, folds them into their goals. Next slide, please. So I provide examples for each of these strategies, right? So an example of offsetting, I talk about Indigo, how Indigo, a carbon credit broker, works with nearly 250 farmers in Minnesota, selling credits for at least $1 a ton of sequestered CO2 to companies like Blue Bottle Coffee and JP Morgan Chase, with farmers keeping 75% of the revenue. As an example of carbon insetting, the Land O'Lakes Tratera division paid over $5 million to nearly 300 farmers to store 260,000 tons of carbon. And Cargill also pays farmers to adopt new practices like no-till or cover cropping on a per ton basis of stored carbon. And then an example of strategic alliance. One strategic alliance occurred when McCain Foods, the potato grower, reached out to the Soil Institute, which is a technical ag advisor for regen practices, to help the McCain growers with a scalable model for regen practice adoption. McCain then reached out to McDonald's to target the fast food industry in Canada, and that's how those connections were made. It's all very symbiotic. But as much as potential as there is in this market failures do exist in the marketplace for regen ag. In perfectly competitive markets, carbon credits have potential, but markets are not competitive in these particular ways. Carbon offsets in the agricultural category are deemed higher risk, a higher type of risk, because carbon capture is difficult to quantify in the sector. Critics say carbon sequestration projects are unquantifiable, unreliable, and evidence of just greenwashing. In my paper, I point out market failures that undermine the market. I point out information asymmetry, difficulties with price setting, imperfect information, lack of transparency, oversight, and traceability. Why do I point those out? Well, one, because they're occurring, but number two is when you have a market that is symptomatic in these ways, that always forces regulation. I've seen this, in food safety and many other areas that I've written about, in nutritional guidance. When you see market failures, that's one direction to go, is into more regulation. Next slide, please. So to conclude, regulations are needed, I feel, to reassure buyers that carbon credits from carbon sequestration are measurable and verifiable, and to reassure sellers that their interests will be protected. And regulation could help to reduce information asymmetry and contracting, and to raise market confidence, to provide a uniform definition and standards for regenerative agriculture, to improve methods for measuring regen ag outcomes and soil carbon, so that firms can in turn count regen ag practices in their mandated climate disclosures. I'll get to disclosures in a second. Another solution I had involved using climate disclosure rules to motivate regenerative agricultural practices. I think, not that this paper is dated, but it's probably dated like 6 months or so, at least. So we've seen some things develop, and my newer publication is transitioning to regenerative agriculture, one net zero claim at a time. So I think I'm working on a trilogy. So the net zero thing is fascinating. But using climate disclosure rules to motivate regen ag, it's also possible, but it's difficult at this time for a couple of different reasons. Like one, the SEC climate disclosure rule and the California climate disclosure regulations are pending judicial review. So there are lawsuits. So that's not a full go right now. Also, European climate disclosure rules are still in place, and they do apply to large firms doing business in Europe, but they too are thinking about a pause. So that is something that is, it's an unhappy moment. If we're trying to look at disclosure rules to add an additional hook for regen ag practices. So I'm going to end with that. Thank you so much. That's it.
napping away at some of those great slides and just really pull together a lot of information in a really powerful way. And I was thinking, I can only imagine from an academic's perspective with the pendulum swinging so wildly in a way that it didn't, in prior years, it's really hard to have your pieces be relevant, right?
Yeah,
I mean,
still relevant, still relevant.
It's almost like you need to, write the A version and the B version, depending on what
Or
administration.
get out of the pendulum swinging business altogether.
Yeah.
Yeah,
I think that's part of the secret.
But then
of what
it's
you're
not
doing.
as relevant.
Well, no, here it is.
This is,
Her whole thing
yeah.
is relevant no
No,
matter
no.
where the pendulum's.
So on that note, next up is Carrie.
Well, thank you all for having me. Thank you for the opportunity to be here to talk about issues raised in Professor Marx's paper. You touched upon so many things that I work on and that I think about, and that I may fall into the category of a critic based on what you're saying. So my comments today are going to go into a bit more detail about some of the limitations of and concerns with relying on carbon offsets as a way for industrial agricultural companies to claim reductions in their emissions or as part of their corporate strategies to achieve net zero, which you also talked about. Maybe we can collaborate
Yes, let's
on
do
that
that.
in the sequel. These concerns fall into roughly 5 categories, which I'm going to refer to as the baseline problem, validity, over-reliance, lack of transparency, and justice. So problem number 1, turning first to the baseline problem. Currently, most agricultural land is cultivated in a way that both emits greenhouse gases and depletes carbon that is naturally stored in the soil. Yet the proposal for agricultural offsets is to change practices on agricultural land that would reduce greenhouse gas emissions or increase carbon in the soil. This creates 2 important baseline problems. One related to the baseline from which we measure the increased carbon storage, and the other related to the baseline from which we measure emissions reductions. With respect to the carbon soil, for decades, industrial agricultural practices have depleted much of the carbon that would otherwise be stored in the soil through land conversion, tillage, and harvesting practices. Industrial agricultural land is currently in a carbon debt. In other words, there's a tremendous amount of carbon that would need to be sequestered and stored in the soil to reduce this carbon deficit and return the soil back to anything close to the carbon content before the land was cultivated. It's therefore slightly problematic to consider every metric ton of carbon that's stored in the soil as offsetting emissions from elsewhere. Only once the carbon debt in the agricultural land is paid off will additional carbon storage truly serve to offset new emissions. There's a similar baseline problem in considering carbon removals from industrial agricultural emissions. Industrial agricultural practices release tremendous amounts of greenhouse gases. In particular, cows, because of their digestive systems, regularly belch methane, a potent greenhouse gas, which is also released from manure storage pits. Cows and manure storage emit more methane than the oil and gas sector in the United States. In addition, producers generally put more fertilizer on fields than what the crops can take up. And much of the excess fertilizer is released as nitrous oxide, which is a very potent greenhouse gas, roughly 300 times more potent than carbon dioxide. And land cultivation to grow animal feed or other industrial scale crops causes the release of carbon stored naturally in the soils, grasslands, and forests. All of these emissions are unregulated because for agriculture, unlike for most other sectors, there are exemptions from most environmental laws and regulations. So there are virtually no pollution limits. So a company can get credit for reducing its emissions that its own agricultural practices are creating in the first place. In other words, companies with exceedingly high volumes of emissions can benefit by reducing some of their unnecessary pollution. So right off the bat, there are issues with the offset system in the agricultural sector, given the questionable starting points for emissions reductions and carbon storage. If there were strong and appropriate emissions limits on greenhouse gases in agriculture, then perhaps going beyond those reductions could be considered credits. Otherwise, the reductions are just a facility cleaning up its own emissions. Problem number 2 is what we'll talk about as the validity problem of carbon offsets in the agricultural sector, which Professor Marks touched upon in her paper and in her remarks. Most of these offsets result from the adoption of practices that will reduce greenhouse gas emissions or increase soil carbon, such as no-till planting, crop rotations, cover crops, shifting to perennial crops that grow food from year to year, so you build a greater root mass, managing manure so as not to generate so many emissions, or grazing in a way that closely mimics migratory bison herds and creates less soil erosion and can increase soil carbon. And while we believe that the shift to these practices is critical to achieve our climate goals and to improve farmers' resilience to climate change, and we support the widespread adoption of these practices, there are several challenges with awarding offsets based on their adoption. For example, these practices are not permanent. They can be reversed at any time, which would then release all of the carbon that was stored in the soil as a result of these practices, which would then eliminate the basis for the offset. There's also no assurance that the adoption of these practices is additional, which it needs to be in order to be considered an offset. Many farmers are already shifting to these practices even without carbon credits. They're shifting to these practices because of other incentive programs, such as under the IRA, the Inflation Reduction Act, or state programs. There's also a risk that these reductions could be double counted. There's little oversight over the market, so such offsets can be counted by the seller, the buyer, the state where the offset, where the land is, where the carbon is being stored, or the state where the buyer is, or countless others can claim credit for the same carbon offset. In addition, increased carbon storage resulting from these practices is very hard to measure, monitor, and verify. It's also very difficult to measure, monitor, and verify emissions reductions. For example, one of the largest sources of agricultural emissions is nitrous oxide, as I mentioned earlier, which results from over-fertilizing croplands. But how much of the excess fertilizer becomes nitrous oxide depends on innumerable factors, and it's obviously hard to measure hundreds of millions of acres of cropland. Similarly, enteric emissions from cattle depend a lot on weather, the breed of the cattle, the feed that they're consuming, and the health of the animal. Current models of these emissions have gigantic error bars. Agricultural offsets will also often be inequitable. For just one example, one proposed agricultural offset would be to pay dairies to reduce the manure methane pollution that they're creating. But they're responsible for causing this pollution in the first place. They've chosen an inexpensive manure management practice that generates methane over more appropriate management practices that would not do so. So they get to benefit from their own pollution, which seems inequitable. In addition to these baseline and validity problems, the third problem is the vast over-reliance on these offsets. To put this in perspective, right now, if we added up all of the stated claims for offsets that companies are making, it would exceed the land available for these offsets by several times. Obviously, that's impossible. The Land Gap report noted that climate pledges by countries that rely on offsets total 1.2 billion hectares of land. This is equivalent to all global cropland. To convert this into offsets would require shifting at least half of this land from its current agricultural use to tree farms, with obvious consequences for food security, national sovereignty, and biodiversity. At the same time, if we totaled up all of the corporate pledges that depend on offsets, companies that plan to offset between 1/4 and 1/2 of their emissions, which is what companies are stating they are doing, if just 24 of the largest companies that were measured in a report reduced their emissions that much and relied on offsets, they would use up almost all available land. They found that if all companies made similar pledges relying as much on offsets, it would require 2 to 4 times the entire global natural resource base. In other words, the corporate pledges and the national pledges combined vastly exceed the total supply of land. So I'll give you just one example, which was touched a little bit upon in Professor Marx's comments. We looked at the world's largest meat company, JBS. The Institute for Agriculture and Trade Policy calculated their emissions were a bit more than 400 million metric tons. Even if JBS were to reduce their emissions by 75%, which itself is an impossibility in the near future for various reasons that I don't need to get into now, and if they just offset the remaining 25% of their emissions, this one company alone would need land the size of the state of Virginia or the state of Kentucky to offset those emissions. That's one company in the entire country. Similarly, a New York Times analysis found that for Amazon to offset all of its emissions, it would require planting trees on an area the size of Costa Rica every single year. Clearly, this is not a viable solution for offsets. The fourth problem is the lack of transparency surrounding offsets, which again, Professor Marks touched upon. In particular, companies' reliance on offsets to achieve their sustainability commitments. In the midst of the growing climate crisis, consumers are increasingly willing to pay more for climate-friendly foods. The growing awareness of food's climate impacts threatens industrial agricultural companies, and in particular, meat companies, whose products are among the most climate-polluting choices for consumers. These companies have therefore tried to capitalize on consumers' shift to more sustainable food choices by marketing themselves as climate-friendly. Many companies, including meat giants like JBS and Tyson, have stated that they will be net zero by a date certain. It's unclear, because these companies don't provide any insight into their plans, if they even have any, to reduce their emissions, how much these commitments rely on offsets. Offsets have therefore become a weapon in these companies' greenwashing arsenals, and reliance on them can mislead well-meaning consumers into thinking that companies are making true operational changes to achieve significant reductions in their climate impact, when in fact they're doing nothing of the sort. The fifth and final problem I'll address is the alarming justice problem associated with agricultural offsets. Given the scope of these offsets that are currently being claimed by companies and by countries, which I talked about before, it's clear that offsetting will need to take place in countries with a large forest cover. That will often be emerging economies. It seems there's a significant justice question with companies from the global north preserving forests or reforesting on land in these countries and claiming credit for that, when these countries also need credits to achieve their own climate goals. There have been some proposals for something similar to an environmental impact statement with some oversight by the United Nations or a similar independent body before any large-scale land transaction occurs between the global north and these emerging companies. So when you put all of these concerns and problems together, we're very dubious about offsets for agricultural activities in particular, despite the tremendous amount of agricultural land and the tremendous opportunity to reduce its climate footprint in the agriculture sector. However, we do want more money, including private money, to go into supporting the shift to more climate-friendly practices. But that must come more from within the supply chain or through insetting, because there is less risk of a lot of these problems and concerns than with carbon offsets. Thanks.
Thanks, Carrie. Those were some sobering facts that you shared. I like the effort to end on a slightly up note. So maybe our scientists will have a different perspective.
Hi, thank you all so much for inviting me to join you today. And as an ecologist in this law space, I appreciate everyone being so welcoming today. So I am a scientist at American Farmland Trust. We're the No Farms, No Food people. We've got those bumper stickers. Maybe you've seen them around. We work to protect farmland from development, get sound, environmentally sound practices on the land, and keep farmers on the land as well. Today, I'm going to make the case that we need to improve soil carbon and greenhouse gas measurements, as Professor Brunet Marks argued, and go further to not only mitigate future climate change, but also help farmers adapt to today's changing climate. Next, please. So first, words matter. So let's define a few terms that we often hear in this space. Sustainable agriculture generally means a food system with no net negative impacts on future generations' ability to produce food. Climate smart primarily focuses on practices that reduce greenhouse gas emissions and/or remove carbon dioxide from the air. Organic agriculture generally means herbicides and pesticides were not used to produce that food. And soil health, according to the USDA, is the continued capacity of the soil to function as a vital living ecosystem that sustains plants, animals, and humans. These terms are not mutually exclusive, but they're also not necessarily overlapping. For example, stopping tillage or no-till is key for building soil health, but can be hard to achieve in an herbicide-free organic system. Regenerative agriculture, next, has a variety of definitions, but generally goes a step beyond sustainable and explicitly refers to the process of restoring and improving degraded land and degraded soil ecosystems and their functions by working in reciprocity with nature. As Professor Brunet points out, regenerative is vulnerable to greenwashing because it lacks a standard definition, which could help consumers navigate the different regenerative labels available today. But certifications can pose challenges for farmers, such as disproportionate barriers to entry for farmers of color and limited resource farmers, which is ironic because regenerative approaches and practices like cover crops, using legumes for nitrogen in soil, and agroforestry have been in use by Black, Indigenous, and other marginalized communities for millennia, predating the word regenerative. We'll come back to this justice element at the end. So altogether, regenerative agriculture involves a transformational paradigm shift away from a more conventional land as a machine mindset towards agro ecosystems working in reciprocity with nature. Next. Before we begin, we talk about mitigating climate change with agricultural practices. It's important to note that U.S. agriculture contributes about 11% of human-caused greenhouse gas emissions to the nation's greenhouse gas footprint, as the other speakers have noted. Over the last 30 years, that percentage from agriculture has increased by about 8%. So where are these ag emissions coming from? Next, please. Nitrous oxide and methane emissions, as Carrie pointed out, and Professor Brunet marks, that those emissions are from soil nitrogen management, cattle burps, and manure management. That makes up about 81% of ag emissions. And I want to point out that that ag soil management part, that brownish bar, is almost half. So that's that nitrous oxide coming from croplands. But notice that none of these big emissions that I mentioned are not loss of carbon from soil. But yet most of what you hear about mitigating climate change in ag is about sequestering carbon in soil. Why? Next. In short, reducing nitrous oxide and methane emissions in ag is difficult and expensive relative to building soil carbon. So sequestering soil carbon is an important and affordable complement to those hard to avoid emissions. Also, the Earth's soils have lost about 133 billion metric tons of carbon due to human activity. So there's room there to put carbon back in soils. It's just not the biggest source of emissions right now. Another reason it's not easy to change the current system to reduce emissions on a farm by farm basis, as you mentioned, is that we haven't invested enough research into understanding when and where these methane and nitrous oxide emissions occur to prescribe specific changes to reduce those emissions, but we are working on it. It's also important to point out here that we do already know how to reduce nitrous oxide and methane emissions by diversifying cropping systems and cutting back on consumption of products like beef and dairy, which sounds simple, but it's not easy to achieve given the current cultural, economic, and political drivers of corn, soybean, and livestock production. Next. By far, one of the biggest reasons we at AFT focus on soil carbon is that carbon building practices have many additional benefits to farms and the environment besides just mitigation. So let's take my friend cover crops as an example. Next. They build soil health, they're regenerative, they're usually climate smart. But I realize I'm in a room full of lawyers, so you might be wondering, what is a cover crop? Normally, after a cash crop is harvested in the fall, a field is left bare through the fall, winter, and spring. And so that soil on the field is vulnerable to wind and erosion. A bare field also means that that soil food web is starving for carbon inputs from the lack of living roots. Enter the humble yet mighty cover crop. Cover crops are generally planted in late summer or early fall. One of the most common cover crops is cereal rye, which is in both of those photos. It grows a little tuft in the fall, like the photo of me on the left in Iowa. It goes dormant in the winter, then greens up and grows tall in the spring like the photo on the right, before termination to prepare the field for the cash crop to be planted. Full disclosure, usually termination involves tillage or herbicides, but we're working on non-chemical, non-tillage ways to do that. Cover crop material is usually not harvested, but it's left on the soil, and that's important for the carbon cycling. So during that fall, winter, and spring, not only was that cover crop holding onto the soil and minimizing erosion, it was also increasing water infiltration by 35%, soaking up excess nitrate, cutting nitrate pollution to waterways in half, and feeding carbon out through its roots into the soil environment. That movement of carbon fuels the soil food web and is the major conduit for carbon to go from the air into soil storage, which is kind of magical. And there's the connection to carbon credits. Next. So now that you are all expert farmers, tell me, during the drought of 2012, would you rather your cornfield, Brad's not allowed to answer, would you like to have your cornfield look like this field on the left or its neighboring field on the right? Pro tip, the corn plants on the left are very unhappy. So during the drought of 2012, farmers who used cover crops the previous fall had 11% greater corn yields on average and 14% greater soybean yields than farmers who did not use cover crops. Cover crops help farmers stay in business. You could also say you take care of the soil and the soil takes care of you. So here's another question next. Would you rather in a spring with seemingly unending rain, your field look like this one on the left or the one on the right? Pro tip, the soils on the left are very unhappy. During the exceptionally wet spring of 2019, farmers were 24% more likely to be able to get out in their fields that had cover crops and no-till and plant their cash crop on time, meaning they were 24% less likely to be a part of the 20 million acres that did not get planted that year, resulting in $4 billion in crop insurance payouts. Again, cover crops helping farmers stay in business. Next. And yet, farmers implement cover crops on less than 5% of the nation's croplands. Why? It's complicated, but basically, there's not enough incentive payments to go around. More people are interested than can get into those programs. I'm not talking about carbon market programs, but other conservation incentive programs. Cover crops are also, they make management more complicated. They're not the social norm at 5%. They come with added risks and costs, averaging around $30 to $50 per acre to manage. And so in order to make all of this worth it to a farmer, a carbon credit payment needs to be much higher than about $10 an acre. But also we scientists need to do a better job collecting the evidence to demonstrate quantitatively how these practices build the climate resilient farms and ranches like we're seeing in those photos. Next. So in summary, I wholeheartedly agree with Professor Brunet's recommendation to improve methods for measuring climate smart agriculture outcomes in soil carbon. We've got a ways to go there. I argue we also need to go even further. Not only do we need to prevent future climate change, we need to deal with the climate change happening now. We need to invest in research to understand which practices managed in which way, in which areas are most effective at helping any given farm adapt. Here's where we come back to the justice part of regenerative. Research investments should include a strong emphasis on adaptation on smaller operations, growing human food, operated by historically underserved producers who face systemic barriers to adaptation. Many of these farms have likely contributed the least greenhouse gases, yet are often the most vulnerable to climate change. Ultimately, building all farms' adaptive capacity to respond to climate shocks helps make U.S. ag lands and food systems more resilient. I can't guarantee that adaptation practices will provide additional leak-proof and permanent carbon storage, but a more resilient food system will help ensure that everybody has something to eat in the future, regardless of the price of a ton of carbon. Next. So lastly, I want to point out that AFT is a 501c3 organization, and we rely on charitable gifts and grants and strategic alliances, as we pointed out in the paper, to do all this work. So if you are moved by the challenges ahead and the opportunities to make a difference in this space, AFT is doing so much cool work right now. Please join us by going to farmland.org/donate. Thank you very much.
Maybe we could pass a hat for you as well.
No, that was great. I mean, we need to have more scientists or at least non-lawyers because literally in 17 years, no one has said the word magical as part of a presentation.
I don't know if I'm supposed to say that as a
I love
scientist,
it.
actually.
Yeah, oh, I see what you're saying.
Yeah.
Well, I just think your enthusiasm, it's really wonderful. And as much as No Farms, No Food has a nice ring to it, I also really think Humble but Mighty, the cover crop, would also, be really great. So, thanks so much for that. And Brad, thank you for coming such a long way, to be here and hand it over to you.
I'm neither scientist nor lawyer, so.
Ooh, there's
Set
a
your
lot of
expectations
pressure
right
now.
But yeah, really appreciate the opportunity to come out for this. It's exciting. It's something we really work on. My initial response to the professor's paper is like, yes, agreed, good thing. The next slide. And I guess my way for just quickly demonstrating that is shortly after IRA was passed, USDA had RFIs for different information on climate smart activities and investments that will be made. And writing those comments in response to that Federal Register notice, I just pulled this selection here to describe how MDA viewed, particularly USDA's role, yes, but in the conversation, particularly around private marketplaces, was a conversation that's been going on for at least 5 to 10 years, but has picked up speed, particularly around 2022 when it's written. Only point I wanted to make there is that first line about singular important purpose of providing service to producers. Our department is like grower facing. And then I think largely reflecting a lot of what was in the papers. We talked about do this in the public interest, but make it a fair and standardized private marketplace without standards, without those, it's hard to be fair. And then, give farmers a support structure so they can participate in these things in a fair way. And then public responsibility supporting and maintaining good that is happening in agriculture already. I'll kind of touch on that in another slide or two. But last point being, if you haven't already guessed, I will hopefully demonstrate a lot, is that my self-assigned role here is to speak about this conversation of markets and credit markets in setting up all those things from farmers' personal interaction with it, or at least my interaction with farmers as a person who delivers programs to them. So that's kind of the lens I want to take to this, is the farmer lens. And I'm just going to respond, next slide. So I'm just going to respond directly to the paper. Let's do keep me on track, hopefully. Next slide.
I'm not the turner of
Who
the
is this
slides. He's in the sky, yeah.
Next slide.
I think we have a slight delay is the problem, so.
That's
we'll
fine.
Fix that next year.
I can certainly adapt to that.
There's a
but-
little lag time.
Point here, just going, yeah, I'm responding directly to your paper. Next slide, please. But talking about the asymmetry and information is that, yes, and I'm really happy to see that you had cited our Farmer's Guide to Carbon Markets in Minnesota that we created with the Farmers Legal Action Group and our Minnesota Farmers Union. Something as a department we were working on already. We identified this opportunity for an additional income stream to growers through their environmental performance. That sounded good to us, so we wanted to explore the markets. In exploring the markets, we said, well, what are they? They're behind a curtain. So we worked with folks. We were able to deliver to actually inform people, the Farmers Legal Action Group, some contracts that farmers that we worked with have had with these private marketplace, to just analyze them for what those contracts contain. Not easy to get a hold of all those, but we got to go out at least half a dozen different of those available. So that the attorneys can look at those for us. Produce the report. In the paper, there's some great points about, the different price structures, all those things. I won't try to go into that now and go over my time, but again, putting this farmer lens on it, the pull quote there talks about something that gets the farmer's attention in particular. The farmer will permit the buyer to, and its representatives or any third party in service of that buyer, that market delivery system, to see their books, to come onto their farm anytime, to you know, look at, go into their operations, their financials, their everything. It's logical, it's appropriate, and I assume in a lot of ways, but it's very uncomfortable and unappealing to farmers, and they are not really jazzed about that. Next slide, please. Which brings the broader point, kind of stepping back up a little bit higher again, though, in the conversation about, you know, what's logical, as I just mentioning. Well, a rational market, a credit trading market, a marketplace in this space, will require that, if just the strict offset that's occurring for Delta Airlines or Microsoft, that, you know, there's happening, that, they're offsetting something, that practice has to be, they're offsetting their pollution today, that practice better be a new practice. And in addition, obviously, in additionality, an additional practice that is acting on that pollution they're emitting today and tomorrow. If that practice has been there for 5, 10, 15 years, a rational market says, well, obviously that's baked in the baseline. There's no credit should be earned for that. Perfectly appropriate, absolutely logical. Farmer lens on that is like, you're really good, you're doing great work. You are barred from this entirely. You cannot participate with us. Those of you who have been leaders and demonstrate great work and doing the cover crops, unless you have never done them before, we won't even talk to you. So the rational farmer, in response to those conditions, will say, you know, if I'm gonna get paid for cover crops, I'm gonna get paid for no-till. I'm gonna wait till I have a signed agreement, because if I do that now, I've just left the money on the table. I don't get it. So I am not gonna do anything to improve my environmental performance right now until I'm insured I'm gonna get paid for it, which is the exact opposite of what Minnesota Department of Agriculture, me and all my programs, and I think all of us here want to see happen, right? We do not want. Worst case scenario is the farmer will say, I have been doing good, but let me just get rid of it. I'm gonna till up on my no-till. I'm gonna cut down the tree row, whatever it might be, so that then I can re-enroll it later and then I can cash it. So that is obviously, again, negative incentives from the circumstances. Next slide, please. Next slide, please. One thing I can't not talk about is Northeastern bankrupt. They're out of business. Truterra shut down. This private marketplace is not necessarily getting its feet under it. The new thing right now that is also essentially on pause, given larger federal circumstances are very far, way before or way after you've written your paper, but is this concept of carbon intensive scoring of agriculture products that has holding some appeal for farmers. And in that respect, I'll try to be real quick with it. It's just, that's just saying how did you grow that grain that is now sold into a producer of energy, in this case, primarily ethanol, that sort of thing. And it's not so much about when was that practice adopted? It's, you know, it's ineligible now because it was 5 years ago or that sort of thing. It's like, well, we're using this product to produce this product. We're using that grain product to produce this product. Was that grain produced in an economic, or excuse me, in an environmental way, climate smart way? And so that's an opportunity. I've already started too much into it, I guess, but it's a tax credit to the producer, not the farmer. And the idea is that such a value to get that tax credit, there will be money paid to the farmers so they can get their good storing grain. But moving on, that's not necessarily the topic today. Next slide, please. I'll just kind of wrap up the last 2 points in the professor's last 2 points into kind of one conversation. Next slide, please. Talking about defining what is a regenerative agricultural system. I'll be maybe a little unhelpful here. The pull quote there is actually California recently. A lot of people I'm sure have seen, they, you know, developed a regenerative agriculture definition, which I, you know, more or less kind of like it. But, you know, it's got a real problem when you talk about standards, is that it, just what it says there, it's not a endpoint, it's a continuous evolution. It's a continuous implementation of different practices and discovering things that are out there and enhancing things that have already been done. And that's what regenerative agriculture is. We've already talked about the 5 principles of soil health. That is another example of kind of the same thing. So do these things that are kind of concepts and implement them. And that's exactly what certainly we drive through our conservation programming in the Minnesota Department of Agriculture. But where's the checklist for that? Very difficult. Just that this is a standard, right? So, in one respect, a ton of carbon is a ton of carbon. If you can find it, if you can maintain it, that sort of thing, but a lot easier to measure than this. But moving on, next slide, please. And I guess next slide after this, on to the last slide. Got to talk about Minnesota, right? So I'm kind of responding to both issues. That maybe we've got an example for it. We not recently, 10 years ago, implemented a water quality certification program, which we do climate calculations off of as well. But we had to certify our farms in Minnesota for the water quality performance. How will you do that? You have the checklist of say, plant and cover crop done. We rejected that. We said, no, we'll do a risk assessment process. You'll just walk onto every parcel on every farm under every cropping scenario and see what risks are being posed. Identify those risks, identify the mechanisms, well-known or new or otherwise, or suites of mechanisms or management changes that will mitigate that risk that's being posed. And that's how you earn certification that we provide our farms. There's 1,200,000 acres certified now, and we're continually moving on to do more and more and more. But that is a standard that is met to obtain certification that is going to be, can be at least wildly different between each farm that's certified. And that's weird in a certification scenario, right? To have farms being very different, have different things that they've done to earn it, but nonetheless, it works, and it's worked for us. We've been talking about economics. I'll wrap up with the final point because I think I probably have time.
You're fine. You're good. Particularly for a non-lawyer, we're giving extra time.
Yeah. So I know this conversation too around credit markets being income for growers. I talked at the outset. We said, hey, let's find new income, particularly what we hope are really public beneficial, societally beneficial actions that provide that income. That would be outstanding. But the underlying concept is like, for them to do any of these really, societally beneficial things, we gotta pay them because, it's just a cost. With this certification program, we were able to access actual farm financials of our participants for 5 years now. We don't know what's gonna happen. The next report comes out next month, but for the last crop year, but our certified farms have always made just more profit than farms that weren't certified. Do this whole farm intervention. It's not like doing that one thing on the one parcel that requires a whole farm intervention. And with that, we found that, again, conservation does pay for these farms. And so the simple point just being, I don't want the credit market or any kind of climate intervention with agriculture to have as its premises. And I'm not accusing anyone of saying it here, but it's a necessity. You're not going to get climate action on farms unless you pay them, and you pay them in perpetuity. I don't think we need to go there. I'll finish.
All right, thank you so much. It's really interesting to hear the state perspective from a true expert on the ground who actually sounds a lot like a lawyer, I'm just gonna say. And I feel like you really upped the game because, I was thinking about those QR codes earlier, as I mentioned, and yours had this cute dinosaur in the middle and it still was functional. So it worked great. I was looking up the document. So Professor, we want to give you a chance to respond to what you've heard before we go to question.
Yeah, I mean, I am just blown away by all of your comments. I mean, I loved everything you had to say, Brad, Bonnie, and Carrie. I agree with so much of it. I wish we could hang out more together. But just maybe just 1 or 2 minutes to just respond to, yes, the problems with offsetting are there. I mean, I think we know there's great difficulty with the offsetting space and, all of like the additionality, the permanence, trying to look at the baseline. I mean, I think there's quite a bit of work that needs to be done if offsetting is going to be something that's used in the future with a lot of certainty. I'm a lot more fond of just the insetting and the strategic alliance space, because I think that is where some really good things are happening with supply chains, where companies aren't just buying offsets and farmers aren't just selling their privacy rights and like they're selling a lot when they sign that line. Whereas the insetting is getting to the entire value chain, transforming, that's really the McDonald's example. The McDonald's example is insetting at its best, and strategic alliances. And I think that's what we're gonna see more of here. So that's where I side, and I agree with everything Carrie said about, the offset space. And to Bonnie's points about, to Bonnie's humble mighty cover crop and and cattle burps and so forth. And yes, I mean, I think I think that a very important point that you made that I really do need to think about more deeply is the justice angle to it. And I think that that's really important. Whenever I go to regen ag spaces and I meet people that are like investors or farmers, and there are really not as many of like the indigenous farmers or community members there, which is really shocking because these are really indigenous practices. So, and I would hate to think that they're being kind of boxed out, mind the pun, out of all those certifications and all the good stuff that comes with having those brands out there. So thank you for that, because I'm really going to look into that. And also for Brad, I love the boots on the ground, the potential in for the carbon intensity scoring and what you've done with like the water monitoring. I think that's all very important. I also don't want farmers to get the short end of the stick here. I really just don't. As a side note, like my husband is a farmer from southwest corner of Minnesota, and comes from a farming family in southwest Minnesota, and they lost the farm in the 80s. Like they lost their family farm. It was dreadful, like having to sell off and auction off all of their holding. I mean, it was transformed him and his family. So I'm sympathetic to farmers and trying to, not make the extra quick buck, but to transition into practices that will put carbon back into the land, that will, increase soil health and also increase like community health. We always talk about like building rural communities and like sustaining rural communities, right? Putting money where people are thriving, where their health is not at stake and not at risk. I mean, a lot of conventional ag is really risky. Fertilizers are risky. They're harmful to health and to the soil and to animals. And it's looking at regen is also looking at like a future rural landscape where families are changing and like dynamics are changing. So I'm grateful for all of your comments. I took lots of notes, but I'm gonna have to see the webinar again.
And you can, everyone.
Yes.
Thank you for that. Jay, do you want to start off with the first question?
Sure, yeah. So one of the ways like you propose to reduce the information asymmetries is like a recordation system for the like carbon contracts. And so I was curious what like enforcement mechanism you had in mind for that. Like, would the credit not be valid until recorded, or, fines or voluntary compliance, or kind of what do you think there?
Yeah, sure. All of those things. If we can get something like that off the ground, I mean, there's so many difficulties already with the offsetting, but having the record keeping has been very, very difficult because as I thought through this in my head, like, what about, rented farmland to farmers and landowners, but what if the land is actually rented, then you're looking at leases, and there's quite a bit to do there. But I'm hoping that, like, in an ideal scenario, if we're looking at trying to further the carbon offsetting market, I think the states would have a registry of all of those credits. Yeah. Anyone else that could lend an idea or thoughts to that? What do you think?
Did you have your hand up? Well, I'm kind of surprised at your kind of favoring insetting, and I might be mistaken, but I've been thinking about insetting as maybe more behind closed doors than offsetting, where a credit is being generated on a farm and it's being verified by, and there's like standards at these registries, and then it's going to a business, sort of like more of a paper trail that's
Yeah.
not regulated, but when it's sort of like McDonald's saying, you know, they're gonna do it this way or whoever, there, each company could set their own kind of methods and standards differently and hold themselves to what they want.
Yeah, and I think you're right about that. So that's the negative, right? Like there can be there's a lot more potential to greenwash. And another angle to look at this from is thinking about all of the disclosures that companies are having to make about their net zero claims. It is such an incredibly dynamic space because the companies have to look down their value chains and have to hold everybody accountable, but to look at what everyone is doing and to measure everyone's participation in that final line is incredibly difficult and not as transparent. A lot more transparent is at the end when a company says, well, we've done as best as we can do reducing emissions, and now we're gonna have to go buy offsets, and we're gonna buy X amount of them. That's the really transparent part. But that's also the greenwashing part, because it's not, you're not reducing your emissions, you're just buying them somewhere else. So
when I think about insetting, isn't that, you know, you are reducing the emissions. In
You
an
are.
ideal world, an offset would be used just for residual emissions.
exactly, ideal world.
And so by
Ideal world.
insetting, you would be reducing the company's emissions as much as they can be reduced. And then maybe looking for an offset or an inset or however you want to phrase it. And so in that sense, when I think about insetting, I think of it as an emissions reduction before you even get to a credit for it.
Yes.
And so that's why, for me, that's why I think that's a better way to go than an external offset.
Yes, yeah, I agree.
I think one example might be our state developed a climate action framework, like maybe other states have, I know other states have, but one of the things that agriculture brought to that throughout the multiple agencies in our state is that maybe wasn't expected by some folks, but said participating in this space is agriculture, it's to reduce our emissions. The sequestration is, we recognize the challenges that are out there and saying like, did this happen? Is it still there? So we're saying, well, our responsibility as an emitting industry is to cut those emissions. We think we can do that and are doing that now, like with, concentrating on the maximum return to nitrogen. We're gonna grow that corn crop. We'll just make sure we put on enough nitrogen so that it's not too much and it's just escaping and nitrate in the water, nitrous oxide in the sky. So yeah, insetting the sense of, yeah, let's attack those emissions. The other side that I'm maybe forcing into this topic, but it's a little bit like the climate smart commodities thing. Is like, well, build something into the product. Going a little way from insetting here perhaps, but that is, it's a climate verified product, and then that will bring itself an added value as an attribute. But when I think when companies, and we start talking about McDonald's or even the sales like through a Walmart or something, is that what history has shown is that there is a desired attribute, a demanded attribute, and that demand means you get to sell it to me or you don't. We're not talking about premium prices here. You get no more money for the cost than you would otherwise get, but we'll actually buy it from you at least. We'll do you the favor of actually buying it because it has the attribute that we are demanding. And so for growers, that's, again, doesn't seem like appealing to them.
Like there's a premium at the store to the consumer, but it doesn't reach the farmer when the product is being
Right.
grain, yeah.
But they say they will, like, I mean, it's interesting because all the big, like, Regen, organic certified, if you look into their label and you talk to people that are, selling this label and trying to get more members into these labels, and they'll say like, the profits go down to the farmer, like this is supposed to be like a very share, something we all share in this vision, but I don't think they do. So they don't, I don't see that. I don't see that happening.
And that's the other element of the greenwashing is,
Yes, of
you can
course.
use that and you can say, we're committed to doing this by 2050, but what's happening between now and 2050? Not much, if anything, but they're reaping the benefit of their claim in the meantime, while they're not doing anything, and consumers think that they're making real changes.
I think another real quick example. Do I have 1 minute? 1 minute. There was at our local grocery store, there was this Applegate Farms had put in a little shack where they were giving away hot dogs and socks. I should have worn them because they're kind of funny. But they were giving away all the swag, and my husband and kids went to King Soopers and they stopped by the shack and they came home with all all this stuff. And they're like, mom, guess what? They're selling regenerative hot dogs. And I was like, you gotta be kidding. And they're giving them away if we have them and they're really good. Like, this is a scam, first of all. Like, it's a hot dog and it's apple. I mean, I like Applegate, but it's a hot dog. So like, you should go talk to them. Go talk to them. Go talk to them. Okay, so I'm gonna hustle over to the little shy PC person. And they, of course, they knew nothing. They like referred me to like a QR code and I could talk to our people, like, these are regenerative. And of course, like, I had to dig further, but so they have like regenerative, they have what they call, regenerative cattle that are feeding off of regenerative grown cropland, right? But they have this big, we're regenerative, and they have their own field to market label, which they've developed themselves. And that's another item that's like not, there's no sufficient label, that's probably another.
There are a lot of labels.
There are a lot of labels, right? But
Well, I know that Professor Vandenberg has a few things to
I've been
say
just about
about.
jumping on my
He's
skin.
gonna push He's gonna push back.
No, we obviously love your paper. We picked it out of the 3 to 500 that Sydney told us about, that we, and Chloe, that we run through each year. We did it because of the regenerative ag piece of it, I would say, more than the regs, because the regs were federal. And I was the EPA chief of staff when Newt Gingrich became Speaker of the House. So I have for 25 years generated scholarship that basically asks the question, what can we do to protect the environment the federal government won't? And that explains almost everything that I've written. And what I worry about our whole conversation is it kind of assumes there's real regulation, which is federal regulation, which, by the way, will not happen for the next 4, maybe 12 years, right? And then there's voluntary activity. And I think that's deeply conceptually flawed. I think that having represented companies and having been in EPA and having been in an NGO, if you have a CFO of a company who is the buyer of your product, tell you, you must do X. And by the way, the Environmental Defense Fund or the World Wildlife Fund or the World Resources Institute is working with them to validate that. And you fail to do X, that's a lot more influential than having a state inspector come by with essentially no authority to do much to you. Kip Viscusi has the leading research out there on the level of material compliance with federal Clean Water Act laws. And it suggests that material compliance is about 75%. So in what we think of as non-voluntary, about 25% of the time, material non-compliance is occurring, right? So I think, need to be really careful in this era. If you think climate change has tipping points and feedback effects and is non-linear, if you think it will have adverse effects for 100 generations, as I do, if you think it's more important than any other environmental problem that we've worked on, then I think we need to be thinking not just kind of what's the perfect solution and what can government do. We need to be broader. We need to say, what can any organization do? And when we do that, and that's partly why we have ELPAR, which is to think about feasibility. So we love the fact that you have a whole system set up that might pretty easily translate into a world in which we don't have government. And again, I'm not anti-government at all. I really am pro-line. I just want to say a couple things about that might address some of these issues. I'd love to see you do your next paper that says, okay, in the world in which the federal government is going to try to discourage, and roughly 50% of your carbon emissions come from states that are trying to stop decarbonization rather than encourage it. I never run those numbers on ag, by the way. That's on industrial source CO2. So that'd be fascinating. But if we assume that states aren't going to do it, the feds aren't going to do it, then what's out there? And just a couple of pieces of information that might be useful. We were starting a project which just got shut down to use AI to disclose greenwashing, because I agree with your point that greenwashing is a real problem, right? And so, but that could still happen. We could still use AI and you can very quickly figure out who's basically bluffing a little bit on some of that, right? So I think that's important. We have to be so careful, though, if you understand psychology, to create a descriptive norm that most companies are complying most of the time. If what we do is what environmental groups traditionally do, which is to say, and we used to do this with Carol Browner and Janet Rita, we would have them in front of a big audience and they would say, non-compliance with pulp and paper mills is widespread. And we went out and took a major enforcement action. I would not be surprised if we increase non-compliance by doing that. Because what we know from the social psych literature, and the tax compliance literature is really good on this, is most people are not doing what the law says they should do. They're doing what they think others are doing. And if business managers become convinced by environmental groups that most other business managers are greenwashing, we're going to increase greenwashing. So what they need to do is they need to believe that most business managers are complying, and that when they're not, then the Sierra Club's coming in, or WWF is, or EDF. And that difference is hugely important. And we could use AI to do that potentially. So we have a paper that's about to come out. I love the supply chain contracting, and I'll shut up in just a second. We have a paper coming out in the Iowa Law Review with a physicist, an economist, and a social psychologist, and we surveyed the retail customers, employees, and community members of companies to try to understand why are companies imposing supply chain contracting requirements on their suppliers in many cases. And what we found is that that group of potentially influential people for customers is attributing to a business the air pollution and carbon emissions of their tier 1 and 2 tier 2 suppliers at almost the same rate as the company itself. So if what you're worried about is brand or reputation or something, then you're as worried about your suppliers as you are yourself. It's not just woke preferences necessarily or whatever. So that's one. The other thing we found in another study recently was that about 80% of the largest firms, the 10 largest firms in 7 global sectors, are imposing supply chain contract requirements on their suppliers. So there's a great foundation for that. And to me, the question is just how in this interim period before government begins better aligning with public preferences on climate, do we find ways to use AI, use NGO pressure, et cetera, to accelerate this? And then lastly, in many other areas like the Marine Stewardship Council and some others, there's actually a private standard for this. And it feels as though there are so many different private standards on carbon accounting that that's a big problem. I wonder if it's time for some kind of a summit on carbon accounting where we might try to simplify. If you think about it, we would not have the market system we have right now if the private sector hadn't come up with accounting standards. It's the only reason you can rely on financial statements to some extent. There's no reason we can't do that in this area too. And I'm not sure why we aren't, but to me, that would be an amazing next paper, is to think about how do we go from relying on a federal government that's not going to act to developing a set of private standards that are as influential as the accounting standards are for finance. Maybe there's a role for NGO activists and the sort of light green and deep green groups and academics in that too.
And
Anyway, that's a lot more than you asked.
I know my colleague who's worked on standards, Jim
Very good.
Pendergrass, has a
A
question.
true expert.
Jim Pendergrass, Senior Advisor with ELI, and that is what I was going to get to. You called for regulation to define the terms and everything, as Mike has pointed out. That's not going to happen. SEC just announced they're not going to the climate rule and disclosure. But there is the International Organization for Standardization, NAST. So maybe orient your call for definition of standards to the International Organization for Standardization, which could do it internationally, to Mike's point. And also to that, I mean, there are the many standard setting organizations for carbon emissions measurement and carbon offsetting. Some of them are doing things on ag and others. And there is an international mechanism and set of organizations that try to hold these various organizations, including the people that are doing certifying and the ones that are overseeing the certifiers. It's by far not perfect. I mean, greenwashing still can occur, but there is a system that seems like might help to take the place of federal regulation, which is
Thanks, Jay. Does anyone want to comment?
Well, as a follow-up, are you referring to the SBTIs and all of those verification systems and like the global, like a global governance, really, honestly?
Yes.
Yeah, that was perfect. That is great. Yeah.
Yeah, I would just add, I think to some of what you're saying, Mike, I think some of it depends on the audience. Like when you're talking about companies and greenwashing, there's the corporate audience, but there's the consumer audience.
right.
And a lot of what we're doing is some consumer education because there's so little transparency into industrial agricultural emissions. And so educating the consumer about the fact that a company like JBS and a company like Tyson cannot be net zero by 2050 unless they make tremendous operational changes is a way to get to what Bonnie was saying, like changing consumer preference and sort of reducing the demand for meat, which is the highest emitting food category that there is. So some of it is an audience issue, but I definitely take your point in terms of the corporate audience.
And we had a piece in Nature Climate Change about a year ago that people tend to think that carbon disclosure is only effective if it changes consumer behavior. And I think that's hugely important. But it's probably a second order effect. That is, that companies worry more about their brand or reputation. They worry about whether the Sierra Club or Greenpeace or another group is going to, so that people won't walk into the store in the first place. Because the evidence from economics that people will put more money into green products is well, it's very limited. The other thing that we found in that research was that a lot of companies are benefiting from this economically because when they have to study their supply chains, they find efficiencies. And the great example is Walker's Crisps in England. They make potato chips. And when they were forced to study the carbon footprint of their products, they found they were buying potatoes by the pound. And so they were inducing farmers to dig them when they were wet, to store them in humidified warehouses, and to ship them in humidified trucks. And so a lot of their carbon footprint was coming from that basic metric they were using to buy the product in the first place. But they wouldn't have found it if they hadn't been forced to try to label their product. And then they find all these inefficiencies. So there are other reasons we might create some incentives that could produce money that would go back to the farmers.
We're gonna take, I feel like it's appropriate to end with a question from a Vanderbilt student. So we're gonna take a question from a Vanderbilt student, thank our panel, and then Nick Summers has some just concluding thank yous, and then we get to eat cookies. So Maddie.
Okay, I don't want to wind up my question too much, but
Uh-oh.
I think that we've talked about a lot of things related to animal agriculture, the human health impact, the animal health impact, with those two. Most recently, the bird flu, the environmental impact. And we talked so much about how to, and companies take so much time to figure out how to advertise certain products and, greenwash and all that stuff. And I wonder, in a group of people who obviously really care about the environment, if these discussions have had any impact on what kinds of things you choose to eat. I personally am vegan, and my reasoning is all of what we've talked about, and knowing that meat has such a huge impact on the environment. And the easiest way to, respond to that is by not eating it and, voting with your dollar by not buying it. You're saying, I'm not interested in contributing to this. So I wonder, in your research, if you've seen any increase in how people are responding to their own eating habits in relation to the information that we're learning about the impact of the environment, and if any of you personally have been impacted by that and considered eating differently.
I can jump in.
Sure. I have a lot to say, but we can talk about that separately. You see me all the time.
So on the personal level, I became a vegan about 6 months after starting my job at Earth Justice because of learning about the climate impacts, I think, most importantly, but then also the pollution impacts and how our food is created, which I think there's a lot of, again, lack of transparency for many consumers. We recently sued Tyson for its greenwashing, and in putting together that complaint, we did look at consumer surveys. And to your point, Mike, there is an increasing amount of consumer demand for more sustainable food products. I don't know that has been translating into less meat yet, but it's certainly consumers are willing to pay more for more sustainable products. And so, what we're finding is that some of these companies that are traditionally not sustainable, like you're producing, it's hard to claim sustainability when you're producing meat on an industrial scale and through industrial processes, but yet they're claiming some sustainability through their marketing in order to capitalize on those markets. And so I do think it's trending towards consumers really trying to put their dollars where their values are. I don't think we're entirely where we want to be yet, but I have seen a shift in the survey data.
Yeah, I don't have the survey data. The surveys I know we have seen is that absolutely in the surveys, they're going to say that when they get to the checkout stand, it often doesn't. It's not the same.
Yeah.
So there's that. I must point out that there's different beef out there. When we talk about our regenerative system, a pre-settlement system, you get almost absurd about it, but there's grazing, there's herbivores, those things are going on. Some of our greatest, of course, producers in our state and other states absolutely are raising beef, livestock, lamb, poultry. but doing it in a regenerative way. And, the other example that people don't talk about, regenerative, sustainable keeps it there, right? Regenerative is building back, and with additional integration of livestock and as laid out in soil principles, there's advantages there.
I think I have to just, our work at Environmental Law Institute on advancing plant-based proteins. And this relates to your point, because what we found in the research is small changes add up and make a big difference. And that's kind of how I personally handle it in my own diet. We have a son who was an athlete. A lot of meat came through our house. I tried to make it sustainable meat. But it makes a difference, that just little changes. And so we have a whole toolkit on things that municipalities can do to advance plant-based proteins by just making them available is huge, right? And then also trying to work with the public to understand the health benefits of making those changes. But I totally go not for the all or nothing as much as I wish I could on some level do what you all are doing. I still feel like I can be a model for a lot of my friends by just saying like, hey, replace that one meal, because it does add up. So,
About food waste, too, you should say a word about that, because that affects this.
well, that's true too. And there are certain foods that are more problematic from a methane emission perspective when they end up in the landfill. Up until 2 weeks ago, we were saying we throw away up to 40% of our food in this country. That number has come down in the latest refed study to be more in the 30% range, but still, we're throwing away 30% of our food. I mean, that's just, absurd from so many perspectives, not just an environmental and waste perspective and a greenhouse gas emissions perspective, but, the statistics on food insecurity are still unacceptable. And so there's so many ways it doesn't make sense, including just the cost, right? So, I do think certain types of food are more problematic.
And
as
given how
well.
much we've all talked, why don't we give Professor Marks one last chance to
Last,
say,
and then we're gonna go to
an umbrella.
we're gonna go to Nick.
Has
and
this
he's
been
gonna
valuable
come
or
up
not?
with-
Where do you go from here?
Yeah, I love the format of this conference, because you're right, I can go home and like really think about this and think about your thoughts, Michael, great thoughts about where to take this and where to like accelerate it and take it forward. I've written a paper, the second one in the trilogy, the third one is still TBD, so maybe, I think about these things all the time. So this is kind of what I do. This is like the love of what I do, teaching and research. And so I'm really grateful for all of the comments that all going in to the next paper, and you'll be all on that footnote. So thank you.
Well, thank you. And Nick, you want to come up, but we're gonna, thank you.
Hey, I am Nick Summers. I'm the executive editor of ELPAR. I will be brief because I don't want to stand in the way of you all and cookies. A few thank yous to our authors for your brilliant pieces, and all our panelists for just the fantastic conversation. Thank you for all of the attendees who are here in person and online. I hope that you found something to be excited about or inspired about and optimistic about confronting challenging environmental issues going forward. I want to thank ELI for partnering with us, allowing us to publish this journal, hosting this conference. Specifically, Mara, I don't know where she's at, but she's been fantastic this year, helping us run the journal day to day and also putting on this conference. I want to thank Professor Vanderbilt and Professor Bregan. The journal wouldn't exist without them. They give us this fantastic opportunity, and to students every year, to do great work and to get this fantastic experience. I also want to thank Chelsea, our symposium editor, for just putting on a fantastic conference and facilitating all this. It was amazing. And finally, all of the other ELPAR members who are back in Nashville watching the live stream. Thank you guys for all of your work this year. You're amazing. And then last three things. The recording will be on ELI's YouTube. The slides will be on ELI's website. And this issue of ELPAR with all of these articles and the comments will be published in August in the Environmental Law Reporter. So let's all go have an excellent reception.
Wow.